All right, let's go on the record. 19 CF 7518. I have counsel for the state defense, Mr. Quiles, present. Good morning, everybody. We had a nice night. So after we concluded yesterday, I did send to counsel a preliminary look at the jury instructions. After I made some edits. The state did send a preliminary copy of the verdict forms as well for all three counts. This morning, I did go over some more of the jury instructions. If you noticed, when I sent it to you guys preliminarily, there were some things highlighted in red. That's what I wanted to talk about. I did format the Williams Rule instruction accordingly. It's a bit different in this case, and there's two witnesses, and one of them testified twice. But in the copy I sent you guys this morning, I tried to clarify as best I could the Williams Rule instruction, so please take a look at that. Yeah. The lesser included charges for counts 1 and 2 being murder and manslaughter with a firearm. If you notice, I combined those two, and I'm fine, and I kind of spaced it out where I said, as to element 1, I said as to count 1, this is the element. As to count 2, this is the element, and I think what I need to do is, when I explain the lessers, tell the jury the only difference between the lessers for counts 1 and 2 is the name of the victim. That's the only element that's different. Maybe come up with some language that way they know for sure that it's combined. I don't want them to have any confusion over that issue. And then on the verdict form, the state included, well, so those are the only two lessers for counts 1 and 2 is murder, second-degree murder, and manslaughter with a firearm as of right now. For count 3, sexual battery, in the verdict forms, the state included a lewd charge. Based on that, I assumed they wanted it included. It is a category 2. There are no category 1 offenses for the crime charged in the indictment. So the copy that was sent to you guys this morning does include that jury instruction. That's not to presuming that it will be included. That was just to kind of give the most information, and we can scale it back if necessary. Because category 2s are permissive compared to category 1, so I needed to have an inquiry with counsel about that issue. Other than that, the jury instructions are rather good to go, from what I can tell. But I wanted you guys to have a chance to look it over at a break and have a good conversation about it before we move forward. Is there anything else that you guys want to add that I haven't stated already?
Not at this time, no, sir.
No, Your Honor.
Is the defense requesting any other lessers for counts 1 and 2 or count 3 that are not already included in the preliminary instructions?
Can we give you that answer at the morning break?
Okay, fair enough. Depending on how
Judge, the one thing I did want to bring to the court's attention, as I was coming out of the parking garage, there was 2 of the jurors there. I did not say anything to them, but I have an obligation to let everybody know. One of them held the door for me because I couldn't get through the metal gate on my own, but I did not say anything to him, did not acknowledge, but I didn't want anybody saying I was trying to talk to a juror or do something I wasn't supposed to, so I wanted the court to be aware of that. That occurred on the way over.
Okay.
I mean, nothing was said. We didn't even look at each other. He just held the...
Sounds like he knew not to say anything. He or she knew not to say anything either.
Both of them more than that.
Oh, there's 2 jurors. Okay.
But we didn't say anything. He just held it. I went by, looked away, and like we always do.
Okay, no problem. Is there anything I need to be aware of what's going on?
Yes, sir, Judge. For purposes of just one, putting this on the record, and two, for also potential rebuttal regarding the brother's testimony yesterday. Your Honor, we have monitoring, obviously, the defendant's calls. Last night,
By phone calls, you mean phone calls from the jail?
last night after close of session, I received this just this morning, probably an hour ago. There's a comment that he made on a video visit. His first name at the moment, Paulette, and his brother, Joseph Quiles, was with her. And they talked, and then witness currently to testify yesterday in support. Joseph apologized to the brother and responded with a laugh. Said that you, brother, that he had created a society. That's a quote. Gave us that society quote. Several other comments about the testimony yesterday. What I would say to the court, I am going to forward two separate emails, all discussions that they made last night about the testimony. I just wanted to make it first put it on the record and disclose it because, again, there's not been a decision about it. It's about what it means to testify. But this record, this is something that certainly is an acknowledgement that his brother did the right thing. The defendant's own work will pay us that society. And our position is, one, now disclosing it to the defense. Number two, subject to cross-examining that information. And number three, denies brother back. This time, Judge, I'll forward both emails that both this morning within about an hour or so ago. I just got caught up on the red shortly before we started, so I will forward both of those.
Okay.
And just to be clear, the comment about the death of society had to do with his brother prior. It is not even an issue.
It appears to be a comment about him testifying and his death in society, but
Is there a video of it?
we'll get our hands on it.
Okay. I'm sure they'll turn that over. I'm sure they'll turn that over to you guys. Obviously, I'm assuming they want to see that before their client makes a final decision on that issue. And I'm sure the state will. I'm sure they got people working on that, if I had to assume. Is that fair, Mr. Skinner? Okay, so but not just the emails, but a copy of the video is going to be turned over to the state, to the defense.
Sending her an email as the court's.
Okay. Mr. Davis, you said you wanted to. Guys, we got to keep the noise down in the courtroom. If you got to talk to somebody, please go outside the courtroom. I'm still in session. Mr. Davis, you said you want to address any motions now at the end of the state's case this morning. You want to do that now?
Give me 1 second, please, Mr. President. Yes, sir, Your Honor.
Can you hear me okay, Your Honor?
Can.
Thank you. Judge, at this time, the defense would move for a judgment of acquittal, specifically as to counts 1 and 2. To start with, the state cannot prove a crime was committed without the statements of the defendant. Specifically, they cannot prove that it was premeditated or whether or not it was the heat of the moment or a crime of passion. They cannot prove where the crime actually committed, specifically that the elements of the crime, that IS and her unborn child are dead, that the death was caused by a criminal act of Johnathan Quiles, and that the act was premeditated, without the defendant's wire statement or wire recorded statements that were on the by the jailhouse snitch. The detective, Billy Abbott, repeatedly stated when he was on the stand on cross-examination that the case turned from a missing person case to that of a homicide case based on the confession and the wire on the defendant. The alleged crime scene at Ace Pick-Apart is based solely upon the confession and the wire of the defendant, and that Detective Abbott specifically stated they could not prove premeditation of murder of IS and the unborn child until they had the confession and that was on the wire. Without Johnathan Quiles' statements on the wire, the state cannot show that a murder has occurred, that there was, in fact, a crime scene at Ace Pick-Apart, and that he had allegedly lured IS up there to a remote area of Ace Pick-Apart and ultimately murdered IS. All of that is based on, Your Honor, corpus delicti. Specifically, the state's entire case hinges and is based on, specifically, Billy Abbott's testimony stating that it's either the confession on the wire or his statements to his brother. As such, Your Honor, the defense would rely on, and I'm pulling it back up, forgive me, Judge, I got to pull up my case sites. I had everything pulled up, Judge, and I got kicked off the internet with where I had everything saved. This up real quick on yours. Mine won't do it. Or there was the JJ case. Judge, I need 1 second because I lost this.
Okay, I do have a jury waiting on me.
specifically, Judge, the state's entire case hinges on and is based on Johnathan Quiles' statements, either on the wire or the confession to his brother. Based on this, in Williams v. State, 689 Southern 2nd, 393, and that is a Florida 3rd DCA case, 1997, and Burks v. State, 613 Southern 2nd, 441, specifically citing to page 443. That's a Florida Supreme Court case out of 1993. And it specifically goes into the state may offer into evidence admissions against interest to establish one or more of the elements as charged, but they must have independently established corpus delicti to prove that the defendant actually committed the crime and or that there was a crime scene to corroborate the state's version of the facts. In this case, Judge, there is no blood, there is no body, there is no murder weapon, there is no DNA, and only the wire and the confession to his brother tie Johnathan Quiles to this case specifically. Detective Billy Abbott specifically stated that without the defendant's statements, they could not approve this case. Judge, without that, there is no corpus delicti in this case, and as such, counts 1 and 2 specifically should be dismissed. Going to count 3.
Can I stop you there? What was the case you cited?
I have 2, Your Honor. The first is Williams v. State, 689 Southern 2nd, 393. That is a Florida 3rd DCA case, 1997. The second case, Your Honor, is Burks v. State, 613 Southern 2nd, 441, citing specifically to page 443. That's a Florida Supreme Court case from 1993, Your Honor.
Okay, go on to count 3 then.
As to count 3, Your Honor, that is based on completely circumstantial evidence of the fact that there may or may not be the defendant's DNA on the pair of panties. The FDLE expert said that his DNA was present, but could not definitively say whether it was a skin cell transfer or whether it was a serology transfer or semen. He said based on his the testing that he had, there was no definitive either way. Again, without the defendant's statements saying specifically on the wire that he had sexual intercourse with the 2 daughters, or excuse me, 2 nieces, that the state cannot meet their burden and prove their case. Again, that is corpus delicti, and I would cite the same 2 cases and ask to take that under consideration for the defendant's judgment of acquittal, Your Honor.
Anything else?
No, sir, Your Honor.
State.
Request to remain seated, Your Honor.
Sure.
Your Honor, the state of Florida would ask you to deny the judgment of acquittal. There is a line of cases. I'm going to cite something more recent than counsel has. Mackerley v. State, Mackerley v. State. It is a 4th DCA case from March 22 of 2000. 25 Florida Law Weekly, D as in dog, 722. Stands for the proposition that circumstantial evidence was sufficient to establish corpus delicti for murder, even though the victim's body was never found. And then it goes on, and a lot of facts, just like we have in our case. In that particular case, Judge, under the corpus delicti portion of the opinion, just to make sure the record's clear, there are 2 paragraphs that are a pertinent note, and it reads as follows. They were basically the situation, judges, they didn't object at trial regarding with respect to either nor argue it at a judgment of acquittal. The appellate court said even if they had preserved the issue, they went on to say this. Even if they had the issue preserved, we would conclude the state of Florida proved the corpus delicti of the murder before Mackerley's confession was admitted at trial. Murder cases in which the body of the victim is never found frequently invoke questions concerning whether the corpus delicti of the crime have been established prior to the introduction of a confession or admission. It cites Myers v. State, 704, Southern 2nd, 1368, a Florida Supreme Court case out of 1997. Also Bassett, 2 S's and 2 T's, v. State, 449, Southern 2nd, 803, a Florida Supreme Court case out of 1984. Goes on to state, as the 5th DCA aptly pointed out in Lindsay, State v. Lindsay, Lindsey, 738 Southern 2nd, 974. That case reads as follows. The term corpus delicti does not mean dead body, but is more properly defined as the body, foundation, and substance of the crime. The Florida Supreme Court has embraced a 3-part test to establish a corpus delicti for murder: the fact of death, the criminal agency of another person as the cause thereof, and the identity of the deceased. In proving corpus delicti, circumstantial evidence is sufficient, and proof beyond a reasonable doubt is not necessary. Again, we're talking about at the JOA, had they objected stage. Obviously, we need to prove it to this jury beyond a reasonable doubt. And they cite, in that particular opinion, SOCHOR v. State, SOCHOR v. State, 619 Southern 2nd, 285, Florida Supreme Court case out of 1993. In this particular case that I'm citing for the court, it reads as follows. Mackerly contends that the state failed to establish a corpus delicti of homicide because the state did not demonstrate that, they named the victim, was dead, and that his death was the result of the criminal agency of another. In considering this argument, it is important to note, to establish a corpus delicti, the state is not obligated to prove the specific manner in which the victim died, nor the identity of the person who committed the homicide. Burks v. State, 613, Southern 2nd, 441, Florida Supreme Court case out of 1993. The state need only present some direct or circumstantial evidence tending to show that the victim is dead and the death was a result of criminal activity. Once the state has presented prima facie evidence of the corpus delicti, the state may then introduce the confession or admission against interest to show that the defendant is the perpetrator. In this case before the court, Your Honor, the defendant, it's not just this wire. There are a load of Snapchat messages from the defendant to the victim that this jury listened to that showed this ongoing relationship and this how enraged the defendant got. All those statements are not on the wire. They're confirmed by the wire. But all those Snapchat statements, Your Honor, were establishing sort of a relationship, establishing this was the only person she was in this relationship with. They were establishing that this is who Jose was. They were establishing that the victim herself, IS herself, Your Honor, was trying to leave him. They established numerous things before we even ever get to the wire. Furthermore, the evidence very clearly shows them meeting up. He turns his geolocation data off at the same time she's leaving Terry Parker High School. Haley Schimpert testified she saw him pick her up. That's connecting them. That's putting them together. That's showing that when she disappears, she's with him. All this evidence that we put forth showing that she no longer exists, her bank statement, family, her last work at Chick-fil-A. She didn't even pick up her checks. We established she did not exist on the face of this earth. We established that when she disappeared, it appeared to be she's walking off school grounds, never to be seen again by family, by friends, by phone. Her phone goes off. All the things that we're able to show to establish she's deceased. This is foul play. This is nothing she did consensually. And here we are 4 years later, she's plus, and she's never to be seen again. The state not only establishes that, but absent any wire, the state also shows in corroboration of the wire prior to the wire ever even happening, he's telling his brother. He's giving his brother, he calls his brother and confesses, which again, as the court knows, we put all three of those confession witnesses on at the very end of our case, having established all these other facts that show this is foul play, she's gone, she disappeared off the face of the earth. The case law supports the proposition that circumstantial evidence does warrant proving corpus delicti. In this case, to answer that proposition, we'd ask the court deny, and for the same arguments with respect to the sexual battery deny the JOA with respect to counts 1, 2, and 3.
Counsel, how do you spell Mackerley again?
Mackerley.
That was March of 22.
Yes, sir. March 22 of 2000.
I'm sorry, I misunderstood you.
Yes, sir.
Is it a fourth ECA?
Yes, sir.
Okay, I found the site. The March date threw me off. It's actually, I think the main date came down on April 2nd. The case is 294 Southern 3rd 311, fourth ECA. I'm sorry, that's not the case. My apologies.
I can give the court my copy. I've got a hard copy as well.
No, it's okay. I'll find it.
If I may, Judge, just briefly,
Oh, yes, sir, of course.
in Burks v. State, I agree with everything that the state said, except the state has the burden of proving by substantial evidence, and this is a quote in Burks, that the state has the burden of proving by substantial evidence that a crime was committed, and such proof may be in the form of circumstantial evidence, but it cannot be just mere evidence to show that a crime is committed, and it need not be proven beyond a reasonable doubt. But in this case, specifically to differentiate, Billy Abbott specifically said that without the defendant's own statements on the wire, he had no knowledge that a crime had been committed and that she was dead. As such, he admitted there was no blood, no body. He couldn't confirm as to what was the murder weapon, and there was no DNA found other than on the panties, and he couldn't say if that was in the commission of a sex crime or not. And then he based everything solely on the wire and the confession of the defendant to his brother. That, Your Honor, is failing to meet the grounds for corpus delicti.
You said March 22nd, 2000?
Yes, sir.
Site 754 Southern 2nd 132, that decision looks like it was quashed by the Florida Supreme Court. It looks like it was a wholly separate issue, though.
Yes, sir. And
Court opinion.
if you go to that third,
Yeah, let me get the site on the record, Mr. Skinner. The site for the Supreme Court case is 777 Southern 2nd 969. Looks like the issue on appeal was a general verdict for first-degree murder on dual theories of premeditation and felony murder. That was the issue on appeal that was certified by the DCA Supreme Court. I want to make sure, even it's a red flag in Westlaw, to see a red flag, your eyes perk up a little bit, but it looks like the issue that was addressed is a separate issue than what's being discussed here in court today regarding the JOA issue. So I just want to make that clear, so it's not an issue on appeal.
yes, sir, thank you. And the reason we're citing it is because it lays out that line of cases that stand for the proposition that is good law. I cited Bassett and Myers and Lindsay and SOCOR, SOCHOR, Drysdale, all the cases that I read when I was going through the body of the opinion, stand for the proposition that even the defense agrees is good law.
I do. In the light most favorable to the state, the JOA is denied. Can you bring the jury back in now?
Right. And while we're doing that, we just need to out 33B. There was an issue with the disc when we had put it in, and we have a new one that actually works properly. It is the second part of the defendant's cell phone dump.
Defense?
Sorry.
The state's asking to replace 33B with a working CD.
No objection.
Okay, you go ahead and take
That's
care
all
of that.
Thank you.
At this point, what I'm probably going to do is not give the jury a mid-morning break. I'll go straight to a lunch hour, take an earlier lunch, and see where we're at.
One moment, Your Honor. Sorry.
Yeah. I agree. Judge, for purposes of, rather than stopping, taking the jury out, do you want to inquire of our client now as to whether or not he wishes to testify?
Does the evidence that the state mentioned this morning change that analysis at all? That's why I was going to wait. But if it's not changing the analysis,
They've had a chance to talk to him, Your Honor. We prefer
Okay. Mr. Quiles, can you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth? All right, sir. So we're at the stage of the ball game now where the state's rested their case in chief, and now I turn to the defense. Obviously, as you heard me tell the jury during jury selection and throughout the trial, the state of Florida bears the burden to prove the case beyond a reasonable doubt. The defense does not have to do anything, does not have to call any witnesses, etc. You have an absolute right to remain silent, and I'm going to talk to you about that. You have a constitutional right to remain silent. If you decide not to testify, the court will instruct the jury that the fact that you do not testify is not to be considered by them in any way whatsoever in their deliberations. And if you recall, we talked about that in jury selection, and I gave an example of that. If you choose to testify, the court will instruct the jury that the testimony is to be considered like the testimony of any other witness. If you testify, the state will cross-examine you and ask you, if applicable, if you are a convicted felon, and if so, how many times. My understanding is that you are not a convicted felon and do not have any convictions for crimes of dishonesty, so the state is not able to ask you that question because they don't have a good faith basis to ask you that question. Is that correct, defense? State?
Yes, sir.
As you saw throughout the trial, a couple times it was mentioned, are you a convicted felon? If so, how many times? That line of questions will not be able to be asked of you because it's not pertinent to your testimony since you do not meet that criteria. The right to remain silent belongs to you and to you alone, not to anyone else, including your attorneys. Your attorneys can give you advice and their opinion, but the decision whether to testify or remain silent belongs only to you. Have you discussed all of this with your lawyer?
I have.
You need more time to do so.
No.
And what decision have you made regarding testifying?
I'm not going to testify.
Is this decision being made voluntarily?
Yes.
Has anyone forced you to make this decision?
No.
Coerced you?
Nope.
Pressured you?
No, sir.
Threatened you in any way whatsoever?
No.
And you've had ample time to talk to your attorney about this decision?
Yes.
You seem rather confident in the decision.
Yes.
Is there any inquiry you want me to make addition to that regarding his decision not to testify at defense?
I know yesterday you mentioned harm and just about in general.
Correct.
Has been done, but as far as that goes, no.
Okay, so I'm putting aside the decision not to testify. I'm going to move over to another line of questionings. But there's nothing else you want me to inquire about specific regarding his decision not to testify? Okay, so the court is making a finding that his decision not to testify has been made freely and voluntarily, and the court will instruct the jury regarding his decision not to testify at the applicable stage of the proceedings. So, Mr. Quiles, it sounds like your defense attorneys are calling a few witnesses to testify on your behalf. I have a general knowledge as to what they're going to say. Obviously, you have more in-depth knowledge than I do at this ballgame because they've talked to you about all this. Have they located the witnesses that you want them to locate to call on your behalf at trial?
Yes.
And you're in agreement with them calling these witnesses to testify on your behalf?
Yes.
And I believe there's 3 of them?
Yes.
Okay, and you're in agreement with that?
Yes.
There's no additional witnesses that you want them to call that they are not calling, is that correct?
You couldn't find the other one, so.
We talked the John Smith and the Larry?
Correct.
Well, I think the John Smith issue got debunked by the states.
Well, the issue is, Judge, actually during the course of the trial, it popped up in the phone record. It's not John Smith. It's a different name. It's John Anthony. So it popped up during the course of the trial. The state did provide information. We did attempt to follow up. But given that the person's out of state, we are unable to complete our follow-up investigation and produce that person. But it was not a John Smith. It turned out to be a John Anthony.
Have you talked to him?
Nope, we have not been able to reach him.
I did call the phone number that was provided by the state. I did not reach him. It was late last night, Judge, so he may call back today at some point, but at this point, he's in, I believe it was Georgia, if I'm not mistaken. Yes, okay. He's in Georgia, and so the likelihood of being able to provide him here, at this stage, it's...
Do you know what he allegedly would say? He was a co-worker at the Ace Pick Apart?
The expectation, Judge, would be that our understanding is that he is on some of the video that the jury observed of him at work. He was with another gentleman during a portion of that video. That gentleman worked with him throughout that day. And so I don't know exactly what he would say specifically, but we would expect that he would provide information as to observations he made of Mr. Quiles that particular day.
Well, there are quite a few people who worked at ACE on that day. We can all agree to that, right?
Of course, but
And none of them are being called to testify.
No, and this particular person is someone who worked with him on a regular basis, and so this is someone who might remember that particular time. I think we did reach out to try and figure out if there were other people who may have worked with him, but we just could not find anybody who remembered that particular time. So,
Because to them it was just a regular day. There was no reason for them to specifically remember this day.
correct, and so they couldn't provide us with any information that would be something to put in front of a jury. Other than
Okay.
speculation of, oh yeah, I don't remember anything abnormal, which I believe both of the Lindros testified to that. So I don't think there was anybody else out there that we could have. This person in particular that Mr. Quiles requested us to try to find, he believed would have a little bit more direct information as to where his movements and activities throughout the day. Not knowing that name, of course, Anthony versus Smith, that obviously impeded us from being able to fully investigate that prior, and we literally received that towards the end of the day or middle of the day yesterday, so it's not like we had a great amount of time to do any additional legwork.
Okay. And then Larry was the other person that had no last name.
We did figure out Larry. Larry was the supervisor that's been discussed as having been on leave during that time period. He was not present during any of those days, so we did not pursue calling Larry, although we did have the information for him, and we did discuss that with Mr. Quiles.
Okay. So the only issue being John Anthony.
Correct.
Okay.
Judge, we just want the court to be aware, as well as we told our client, we've literally made every effort to make sure no stone is left unturned.
Understood. So Mr. Quiles, going back to you, sir, you're in agreement with these three witnesses being called on your behalf, correct?
Correct. Yes, sir.
Okay. And so when I asked you about any additional witnesses, it was the previous issue that we discussed regarding John and Larry.
Yes.
Other than that, is there any other issue or witnesses you want your attorneys to call to testify at your trial?
No, sir.
Have they done everything that you asked them to do in this case?
Yes.
Obviously, throughout the course of the trial, I've noticed that you've taken extensive notes on a legal pad. I've seen you talk to Ms. Michelle and Mr. Davis quite a bit. You've been engaged throughout the entire trial. You've taken quite a bit of notes from what I could talk. I don't know what you're writing, but you're writing something. And you've been conversing, ripping papers up, giving to your attorneys to ask questions, I'm assuming, of certain witnesses. Have they been engaging with you throughout this entire trial?
Absolutely.
And they've been taking your advice of issues that you want them to address?
Yes.
And you believe that they've done a good job for you?
An excellent job.
Good to hear. So I'm assuming based off that you're satisfied with their services here at this trial.
Yes, I am.
Is there anything else you want to bring to my attention?
No, sir.
Has anyone told you how to answer my questions here today?
No.
Anything else the defense wants me to inquire about?
No, Your Honor.
Anything the state wants me to inquire about?
No, Your Honor, thank you.
Okay, so at this point, we'll go straight through the morning. We'll take an earlier lunch. We'll see where we're at, if there's a rebuttal case or not, but if not, we'll start closings this afternoon after the lunch hour.
Judge, could I inquire, when you had the clerk come get me, I was in speaking with one of the witnesses in the conference room. As the jury's coming back in, can I go finish up with him to make sure he's ready and on deck to be called when Ms. Michelle's ready?
He's not the first witness?
No, he's going to be the second witness
So you want to talk to him in the interview room while Ms. Michelle is inquiring?
of the first witness that she's going to call, yes. Just so that we have
Okay.
ready to move him straight to the chute and ready to call.
The staff can accommodate you. I'm sure it can happen.
Thank you, Your Honor.
Okay. Any reason why we can't bring the jury in?
No, Your Honor.
Defense?
No, Your Honor.
Okay. Let's bring the jury back in, please. Members of the jury, welcome back. Everyone may have a seat. Sorry for the slight delay this morning. I had to do some work with the attorneys outside your presence. Because of that, what I'm probably going to do is take an earlier lunch break for you guys. If that presents an issue for any of you guys, just let me know. I'm not going to go to 12:30 straight, I promise you guys. If I take an earlier lunch, if that presents a problem, slip a note to the bailiff. I'll certainly accommodate you guys. But with that said, we're going to begin. The state rested their case in chief yesterday. You guys all have your correct notes? Okay, people are shaking. Okay, good. So the state rested their case yesterday. I'm going to move forward to the defense side. Mr. Davis, Ms. Michelle, you can call your first witness.
Defense would call Carol Clip.
Ms. Clip, good morning to you, man. Come over here to your right. Just watch your step as you come forward. Need a glass of water, let us know. Mr. Gray and the staff will certainly accommodate you.
I'm nervous, but I think I'll be fine, thank you.
Yes, ma'am. No reason to be nervous, but I understand why. You can manipulate that microphone to help you project your voice. And I just ask if there's an objection made by one of the attorneys during your testimony, just pause, let me rule on the objection, and we'll go from there, okay?
Yes, sir.
All right, ma'am. With that said, state you may inquire. You're ready.
Yes, Judge, thank you. Good morning, ma'am.
Oh, there you are.
Yes, I'm right. Good morning.
Good morning.
Could you please begin by introducing yourself to the jury, please?
My name is Carol Ann Clip, and I live here in Jacksonville, and I work for the health department half my life.
Thank you so much for giving us that. Are you related to anyone in this case, Ms. Clip?
No, ma'am, I'm not.
Do you know anyone by the name of Johnathan Quiles?
No, ma'am, only through this instance now.
And did you hear that through the news?
Excuse me?
And did you hear his name through the news?
Yes.
Okay. Outside of hearing his name on the news, had you ever met him or spoken to him or know anything of him?
No, ma'am.
Do you know, maybe from the news as well, outside of what you may have heard on the news, did you know a young lady by the name of Iyana Sawyer, IS for the record?
No, ma'am.
Did you know anyone that was related to her at all?
No, ma'am.
Do you recall a time in December of 2018 where you witnessed something noteworthy?
Yes, ma'am.
Can you tell us what you witnessed?
I was coming home from my mother's house in Tampa at Christmas time, and it was actually the late afternoon or evening of Christmas. And I came down off the 95 ramp to come down on Phillips Highway. Well, I had to stop at that light there. It just wasn't green and you could just go. So I was stopped behind several cars, and the light turned green, and as the light turned green, it went and merged onto Phillips Highway. And as I did, I noticed this young girl walking in front of the two hotels there. There's two hotels right side by side. And I noticed her, and I thought to myself, it's going to be dark soon. You know, no young person should be walking down, headed south on Phillips Highway when it's going to be dark shortly. And I was concerned. And then I got home, and I didn't think anything more of it.
All right. And you said that you were concerned. Is that something that you thought about later and wondered about what was going on with her?
Well, later on, I think it was several days, I saw on the news, I was actually sitting in front of the TV, and I saw the news about the missing girl. And through their description and the picture I saw of her, that was her. In my heart and mind, that was her. And so I had to call. I had to call the police and say that I had seen her.
And did you do so?
I did so.
Did you do that right then and there?
I did that the very day I saw that on the news, yes.
When you called her, did you tell police what you've relayed to the jury just now?
Absolutely. And I probably even went further because it was more fresh in my mind.
And I was going to ask you some of those details. I know you told us where you saw her and you saw her walking. Do you remember what she was wearing?
I remember her hair. I remember a backpack. I remember, that's about all I remember. But I know that whatever it was, I told the police whether it was more or less was what I saw, which was more fresh in my mind 4 years ago.
Of course. And when you made that phone call, why did you call right then and there? Tell us your thought process.
Well, because I was concerned. And if you see, and I believe in that. And so, therefore, I did.
That when you saw that news, the picture and the description that you called then, how certain are you that the young lady was in fact that same young lady that you saw in the news that was missing, IS?
Well, if I was not certain in my heart, there would be no reason to.
Let me ask you a couple last questions. Did you want to come here today to testify?
It's kind of scary.
I was going to ask you that. Is that why you are testifying?
That's why I'm here.
And what you've told us is what you saw. No, as best your memory can recall, no additions, no subtractions.
No, that is true. This is what happened.
Thank you.
You're welcome.
Nothing further.
Yes, ma'am.
Besides the nervous part, huh?
I've never done this.
So, ma'am, I'm going to obviously talk to you about back in December 2018 and January 2019. This individual that you observed, it was on December 26, 2018, between 5 and 6 p.m. Is that correct?
It was the 25th. It was Christmas.
Do you recall telling the police that it was December the 26th, 2018?
No.
Okay. And do you recall...
Oh, you know what? It may have been because I spent Christmas at my mother's. Pardon me.
That's okay. Did that help refresh your recollection?
Yes, thank you.
No problem, ma'am. And you had told the police that it was between 5 and 6 p.m. Is that fair to say?
If that's what I told them, then that was the truth.
And it was getting dark, wasn't it, at this time?
It was going to be soon, and that's why I was concerned for that young person.
And you recall the fact that this individual had a backpack.
I do.
And I think the other thing that you remember is that this individual had hair extensions.
I do.
Okay. And you stated that then on January 1st, that would have been 5 days later, correct, that you saw a picture on the news?
Possibly, yes.
Okay.
I knew it was several days. I don't know the date.
Do you recall what picture you saw on the news?
I do not.
And had you ever seen the individual by the name of Iyana Sawyer before?
I don't believe so.
And
I was what, ma'am?
it's fair to say that you were driving at this time, correct?
I was driving. I was stopped. The light turned green, and I proceeded around to Phillips Highway.
Yes, ma'am. Is it fair to say that the total time that you saw this individual while you were moving was 5 seconds, correct?
About 5 to 7 seconds, yes.
No further questions, Your Honor.
Ma'am, good to see you. Ms. Michelle, you can call your next witness. Yeah.
Your Honor, if we could next call Ulysses Dixon.
I'm aware. Yeah, I think Officer Hill tried to ask him outside. I know. I just didn't know the. Mr. Dixon, good to see you, sir. Just walk up here in front of the clerk. Mr. Dixon, good morning to you, sir.
Good morning, sir.
You need a glass of water, let us know. We'll do our best to accommodate you. There's an objection made. I just ask that you pause and let me rule on the objection. We'll go from there.
Yes, sir.
All right. With that said, Mr. Davis, you may inquire. You're ready.
Thank you, Your Honor. Good morning, Mr. Dixon. Would you please state your name and introduce yourself to the jury, please?
My name is Ulysses Dixon II.
Okay. And where are you currently housed?
I at the PDF detention facility at the county jail.
Okay. So you're at the Duval County Jail, right?
Yes, sir.
How long have you been at the Duval County Jail?
I've been at the Duval County Jail for about 6 years.
Okay. Now, just to be clear, 5 prior felonies, right? In your history?
Yeah, I don't know how many, but yes, I have felony priors.
Okay. And you have pending charges as well, correct?
Yes, sir.
How many pending charges do you have?
I think the state amended it when I was about to go to trial. I think it's like 13, 12, 13.
Okay. Now, are any of those crimes of dishonesty?
No.
Okay. You don't have prior crimes of dishonesty?
Oh, that's not what no, sir.
All right. Now, at the jail, are you involved in a Bible study group over there?
Yes, sir.
And how long have you been running a Bible study group at the jail?
Since 2018.
Okay. And do you run the Bible study group?
Yes, sir.
Okay. It's something you set up on your own, right?
Yes, sir.
It is not affiliated with anything through the jail or some other religious or ministry group or anything like that, correct?
Correct.
All right. Now, do you give incentives to people that come to your Bible study group?
Definitely, like food and extras. Yes, sir.
Okay. And do you follow up with people that come to your Bible study group on a regular basis?
Definitely.
Okay. And just to be clear, this is done in the dorms there at the jail, correct?
Yes, sir.
All right. Do you do an outreach program to recruit new members and get new people that are coming in to attend your Bible study group?
Yes.
Okay. For lack of better words, are you basically like the minister or conduct this ministry yourself?
Yes, sir.
Do you bring in a minister to participate in this?
Do I try to encourage other people to preach? I do.
Okay. All right. Do you have an occasion to know the name Damian Hatch?
Damian Hatch, yes, I do.
What name does he go by at the jail?
Dino.
Dino. Okay. And do you know Johnathan Quiles?
Yes, I do.
And how long have you known Johnathan Quiles?
I know John probably since either 19 or 20. It's been a long time. It's been a while.
When you say 19 or 20, you mean 2000?
2019, 2020.
Just so the record's clear, let me finish my question, and I'll let you finish your answer so that this young lady can take everything down, okay?
Yes, sir.
All right, thank you. All right, now, I want to go specifically to around February of 2022. Was Dino or Damian Hatch attending your Bible study group regularly?
Around 21, 22, yes. Dino was a regular.
Okay. And do you recall, or do you know, has Johnathan Quiles ever attended your ministry or religious groups?
John started right about the beginning of this year, maybe January, December, somewhere around the beginning of this year, end of last year. But
so from 2018 until to the end of 2022, he did not attend your religious or ministry group.
no, he didn't. Though I tried to, convince him to start attending services and seek Christ.
How are you certain he did not attend?
Because I lead the Bible studies. I do Bible study after lunch. It's more in-depth, get into, hermeneutical interpretations of the books. And then at 6 o'clock services, that's the main service where it's like preaching, hallelujah, thank you, Jesus, and encouraging the guys, exhorting the flock to just continue in the doctrines of our Lord and Savior Jesus Christ. And he wouldn't attend. But he went by the name Brother John, so I was like, bro, you're a brother. I should try adamantly, because he does a lot of good stuff in the jail, clipping toes for the old people. When the guys, they have bowel movements on themselves, he wash them. He do a lot of good work, but he don't come to church. So that stuck out to me.
All right. And have you ever seen Dino and Mr. Quiles hanging out at Bible studies together?
No, because John don't come.
Okay. Well, he didn't come at the same time that Dino was.
Yeah, not at that time. Dino was in Bible study. John wasn't.
So if somebody were to say that Johnathan Quiles attended your Bible study and was there with Dino, would they be telling the truth?
That Dino attended it with John, that's a lie.
Okay. Did you ever see them hanging out together after the Bible studies?
No.
Okay. All right. And how are you certain of that, of their attendance?
Well, I have records. I keep up with the flock. The Bible says be diligent to know the state of thy flock, and so I keep meticulous records. I have the names of the regular main attendants, and if guys just pop up and make a guest appearance, so to speak, I write their names on the bottom in that section so I can follow up and say, hey man, I seen you at church today. I just like the service, woo-doo, and Just try to bring them in, usher them to Christ.
Before you came over here to testify today, did you review your records to ensure that they were accurate, that Johnathan Quiles never attended your services before this year?
Yeah, I turned them in to the people that came and asked me about them. They asked me, you guys asked me, and I said, I got records to prove if you think.
Okay. All right. You also showed those to detectives when they came and talked to you?
No, I didn't show them to the detectives. I didn't know why they was calling me out.
Okay. All right. May I have just a second with Counsel here?
Morning, Mr. Dixon.
Good morning.
Now, sir, you have pending charges that you're currently facing right now. Is that correct?
Yes, sir.
And there's 13 of those, right?
Yes, sir.
You brought them up. What are they?
What are my charges right now?
Sir.
I have human trafficking, deriving financial support from the proceeds of prostitution. There's kidnapping. There's aggravated battery, possession of firearm, sexual battery.
All right, you left a few out, didn't you, sir?
I think I was correct with all of them.
Okay. You said human trafficking. Is that correct?
Yes, sir.
Isn't it true, sir, you have 2 counts of human trafficking charged against you?
Yes, sir.
And then you said sexual battery. Is that correct?
Yes, sir.
Isn't it true you have 6 counts of sexual battery charged against you?
Yes, sir.
And then you mentioned kidnapping. Isn't it true, sir, you have 2 counts of kidnapping charged against you?
Yes, sir.
And you have 1 count of aggravated battery. Is that correct?
Yes, sir.
And then you have 1 count of deriving support from the proceeds of prostitution. Is that correct?
That's what I said.
Yes, sir. And then you said a possession of a firearm. Did you mean possession of a firearm by a convicted felon? That was charged with?
Yeah, that's more formal. Yes, sir.
Okay, thank you. Now, you are a convicted felon, right?
Yes, sir.
How many felonies do you think you have?
Well, 2.
Okay. Counsel asked if you had 5.
4. I don't know. Probably 3, 4, 5, maybe.
You keep meticulous, detailed records about who attends your Bible study, but you don't know how many felony convictions you have, sir?
I mean, if you gave me my record, I could show you that, like I could show you the records for my Bible study.
I'm asking you about what you think. How many felonies do you have?
2, 1, 4. I thought I had 4.
All right. Now, these charges have been pending against you since 2017, right?
Correct.
And they were filed by the state attorney's office that I'm a member of, correct?
Correct.
And you agree, sir, that you're fighting those charges.
Yes, sir.
They're pending right now.
Yes, sir.
Now, this group that you lead over at the jail, excuse me, this takes place in the pod, in the dorm, is that correct?
Yes, sir.
Like, if I'm laying in my bunk on the 1st or 2nd floor, the group can be heard right down there in the pod, correct?
Yes, sir.
In fact, you can see from each respective bunk, you can see in the dorm when the group is meeting, right?
Yes, sir.
In fact, everybody can see it.
Yes, sir.
In fact, when you meet as a group, do you agree, sir, that you meet at one section of the open dorm that's open to all?
That's changed.
I'm talking about back in the time period you're testifying about. Not now, not today, but back when we were talking about 2022, 2021, 2020, 2019. Right?
When we made that conversion from the secluded area to the open area, that was around about 22.
Okay. And the defendant, you've seen him in your dorm since 2019, correct?
I don't believe I was in the dorm with him at 19.
All right. You said to this jury just a few minutes ago, sir, under oath, that you've known him since 2019.
From 1920, we weren't in the dorm together when I first met him.
All right. How'd you meet him?
He works in the jail. He was a trustee, what they call it, pass out the trays, help people, stuff like that.
All right. When did you become a fellow inmate in the same dorm or pod with him?
Probably 20, 19 or 20. I'm not
Okay.
for sure about that.
All right. And in 2019, 2020, he was new to you when you first met him, obviously, right?
Correct.
And when you are doing your Bible study, can it be heard over the whole entire pod, the whole dorm?
Yes, it can.
All right. And how many people are in this group?
It varies. It fluctuates between 10 and 30. It fluctuates between that.
All right. And when the group breaks, I take it you end with a prayer?
Prayer.
And when the group breaks, everyone just disperses, correct?
Shake hands, dap up, hug, and then they go their separate ways. Put up their Bibles and go back to what they're doing. Get on the tablets and the phones.
Yes, sir. And when these either 10, 15, up to 30 people break, are you watching every one of them?
Not every one of them. I hug and dap up every one of them. I don't watch what they do after they leave.
So when you say leave the Bible study group, you agree with me, you cannot watch all whatever number are appearing on that particular day. You agree with that, right?
That I can't watch all of them after the service is over?
Yes, sir.
No, I can't watch all of them at the same time.
And when the service is over, if we're meeting over here in a group and you walk 10 feet away, you're no longer with the group, right?
Correct.
And as you get further away from where you're meeting, you can't hear what they're saying, right?
Correct.
Pretty loud in there, right?
Correct.
I mean, this jury's heard a wire. You hear banging on doors, correct?
Correct.
You hear that quite often in there, correct?
Correct.
You have no idea what any member of your group is talking about or who they're talking with once they leave your group. All 30 of them, can you, sir?
Yeah, I don't see what they're doing after they leave the service.
One moment, Your Honor. Nothing further, sir. Thank you.
Just briefly, Your Honor. Follow up on what Mr. Skinner had just asked you a minute ago, sir. Back a year plus ago, the way your Bible group met, you said it was in kind of a secluded off to the side area?
Yes.
Was that accurate?
That's accurate.
Okay. So although people inside the dorm can hear it, that you're doing this Bible study, you can, when they were attending, it was like in a separate off to the side room or area, correct?
That's where we do church at.
Okay. Now, as such, it's kind of off, as you stated, off to the side. You can tell who's attending and participating in your church services, correct?
Correct.
And as part of that, if somebody states that they saw Dino and Johnathan Quiles together at the church service over there off to the side, they would not be telling the truth. Would that be accurate?
They would be lying.
Okay.
John didn't go to Bible studies. I mean, after church over with, I stay at church, walk everybody to the doors, leave them this way or that way. How they would do at a real church, how you walk your members out the door, I would shake their hands and tell them God bless you until the last member gone, because people want to talk to you after church. And so I stay. So if anybody else stay, I would see that. But if they go somewhere else, if they go to a room, if they go in the shower together, I can't see that.
Okay. Now, one last question. Anybody promised you to be here today? Promised you anything to be here?
No, actually, I feel threatened that if I, come forward with the information, that they may respond against me. The state attorney's office may try to go hard on me for my charges. But, they trying to kill this guy, and the dude was lying on him. So I told him, I would agree to tell him that, man, that's a lie. The dude lying on him.
Nothing further, Your Honor.
All right, Mr. Dixon, have a nice day. Defense, you can call your next witness.
Your Honor, the defense would next call Kamar Humphrey.
Mr. Humphrey, good morning to you, sir. You just come on forward, and the clerk right here will swear you in. All right, Mr. Humphrey, come over here to your right. Just watch your step as you come forward. If you need a glass of water, let us know. Mr. Gray, the staff will accommodate you. Do you want one?
Yes, sir.
Okay, Mr. Gray will help you out with that. The microphone can be adjusted to help you project your voice. You seem like you have a soft voice, so just try to project your voice with that microphone so everyone can hear you. You can scoot forward however you deem necessary. If there's an objection made during the course of your testimony, I just ask that you pause, let me rule on the objection, and we'll go from there, okay?
Yes, sir.
All right. Ms. Michelle, you may quite ready.
Yes, do you want a moment to get the water? Okay, I'll let you have a moment to do that.
Thank you.
You ready, sir? All right. If you could please, sir, start by introducing yourself to the jury, please.
Hi, my name's Kamar Humphrey.
All right, and Mr. Humphrey, how old are you?
I'm 25.
And where do you reside currently, just generally?
North Carolina.
All right. And back in 2017, 2018, where did you live?
I live in Jacksonville,
And where specifically?
7843 India Avenue.
All right. Sir, if you could, do you recall a time period around February and March of 2018?
What was your question?
Do you recall a time period around February or March of 2018?
Which time period are you talking about?
Where did you reside around February or March of 2018?
It's on India Avenue.
Okay. And sir, did you have neighbors at that time that you knew to be Iyana Sawyer?
Yes, ma'am.
And how did you meet IS?
Walking, neighborly, just walking up the street, picking up my little cousin from school, and she'll be picking up her brother from school.
And did you all talk to each other and have conversations?
Slightly, yes.
At some point in time, did you all start communicating more?
Yes.
And how would you all communicate?
We communicated through social media.
Okay, and what social media apps did you use specifically?
Snapchat.
On Snapchat, do you recall what your Snapchat was at that time?
No, ma'am.
Do you recall what IS's Snapchat was at that time?
No, ma'am.
Do you recall IS having multiple Snapchats?
No, ma'am.
Do you recall having a conversation with her about those Snapchats or anything about Snapchat at all?
No, ma'am.
How did you all exchange information?
Like I said, I met her while walking, so we were just neighborly like that.
Did you all exchange phone numbers at one point?
No, ma'am. No phone numbers.
Did you all exchange social media handles? Is that how you got connected?
The Snapchat, yes, ma'am.
And was that the only social media accounts that you used to communicate with IS?
Yes, ma'am.
All right. In March of 2018, did police come to your home?
I believe so, yes, ma'am. In March, yes, ma'am.
And what happened when police came to your home?
I believe this is the time I did the mouth swab, I believe.
And what did they tell you why they were doing that mouth swab?
For a rape kit or something like that.
Were you in a sexual relationship with IS?
Can you describe a sexual relationship?
Whatever you believe a sexual relationship is, were you in any sort of sexual relationship with IS?
Yes.
How many times had you and IS slept together?
Once.
Have you ever stated anything differently than that?
At one point, what do you mean? Have I ever stated? What do you mean?
Have you ever said that you slept with her more than once?
No, ma'am.
Have you ever denied having slept with her at all?
Yes, I did. I did deny.
When was the last time you denied sleeping with IS?
With the deposition that we had.
Do you recall when that deposition was?
No, ma'am, I don't actually remember the days that we talked on Zoom.
Was it just last month?
Yes, ma'am. It was recently, yes.
In fact, it was just like a few weeks ago, in fact.
Yes, ma'am.
And a few weeks ago, you said you never slept with IS.
Yes, ma'am, I did.
That was not the truth, correct?
That wasn't the truth. At the time, I felt like you were attacking me when you were asking me questions at that time, so yes, I did.
All right. Let me ask you about following that. You're saying you only ever slept together one time?
Repeat your question?
You just testified you believe you only slept together one time, correct?
Yes, ma'am.
Okay. Did you all have a continuous relationship thereafter?
No, ma'am.
Did you all continue to communicate on Snapchat?
No, ma'am.
How long, if you could estimate for me, how long you all were communicating on Snapchat? Are you having trouble hearing me?
A little. I'm just trying to make sure I hear your question as clear as possible.
And I'll elevate my voice that way I make sure you hear my question fully. Did you hear my last question without any issue? You're kind of leaning your ear towards them.
Could you repeat it one more time?
Of course. How long in total do you believe you communicated with IS on Snapchat?
Probably like a month or two. It wasn't that long.
After police came to your home and asked you about this sexual encounter that you had with IS, did you continue to see her?
No, ma'am.
Did you continue to live on India Avenue?
Yes, ma'am.
From the time that this occurred up until when did you continue to live on India Avenue?
Repeat your question again?
How long did you continue to live on India Avenue?
For a couple years until I think the year of 2020 when COVID hit. That's when my aunt and my uncle moved. I was living with my aunt and my uncle. We moved to St. Augustine.
So during the time period of December 2018 and the months leading before that and after that, you were living on Indiana Avenue across the street from where IS was residing?
Yes, ma'am.
At no point after you were accused of having sexual encounter with IS did you move away until 2020?
Could you repeat that? You said a lot when you were...
I know. Let me slow it down. During the time period before December 2018 and immediately thereafter, you continued to live across the street from IS.
Yes, ma'am.
Did you see her?
No, ma'am.
You would not see her at the bus stop picking up her siblings?
No, ma'am.
Did you stop picking up your siblings?
Yes, ma'am.
Okay. Did you go outside of the house from time to time?
Yes, ma'am.
Did you see other family members at any point outside of your home of IS?
I wasn't really paying attention to the family. I was just focused on work.
Do you recall in December of 2018 being visited by police at your place of employment?
Yes, ma'am.
Where were you working at that time?
Popeyes off of Arlington.
And I know you probably don't remember her name, but it was a female detective that came to see you?
Yes, ma'am, it was.
Okay. And what did she ask you at that time, if you can remember?
And she just asked me did I see her and if I had any thing to bring to her or any information just to contact her.
Okay. At that time, did she also ask you where you were on December 19th and 20th?
Did she ask me? Repeat that one more time, I'm sorry.
Did she ask you at that time where you were on December 19th?
I don't recall if she asked me. I don't recall, Sheriff. I know she just, like I said, I remember her asking me about, if I've seen her and if I have any information or anything about that, just to respond back to her.
Okay. And do you recall, I know you don't recall her asking you that question, but do you recall volunteering the information that you believe you were out of town from December 19th until December 29th of 2018?
I was out of town between the times of December 18th. I left December 18th out of town.
And do you recall telling the officers that it was actually December 19th through the 29th?
No, I don't recall telling the officer December 19th. I don't recall telling her December 19th.
Okay. Have you ever stated that you were out of town on different days than those dates that you've just provided of December 18th?
Yes.
Okay. In fact, just a few weeks ago, didn't you tell me that you were in town on the 19th and the 20th?
No, I did not tell you that.
Do you recall ever saying that you were only out of town from December 21st through December 23rd?
I recall telling you that because like I said, in the deposition that we had, I felt like you were attacking me and I gave you the wrong dates.
Do you recall telling me that you took a plane on December 21st to go visit your dad?
Yes, I remember telling you that.
Do you recall checking your calendar to figure out what dates you were gone around that time period?
Yes, I remember. And I didn't take a plane either. I took a bus.
Do you recall having any information at your disposal at that time to be able to verify those dates?
At that time, no, ma'am.
So did you, in fact, look at your calendar at that time just a few weeks ago?
Repeat your question?
Did you, in fact, look at your calendar a few weeks ago to figure out that you were gone the 21st through the 23rd?
I looked and found that I was gone between the dates of the December 18th through the 28th, I believe it was, or 29th, to go see my father in Harrisburg, Pennsylvania.
And let me ask you another question. Do you remember your response to when I asked you about what airline you used?
Again, no, ma'am, because, again, like I said, when we had the deposition, I felt like you were attacking me when you were asking me questions, so I was not truthful with you, and I came back and I apologized because, I should have been truthful, so, no, ma'am.
And I know the incident's from quite some time ago. Is there a reason why you would feel attacked when asked when you were out of town or in town?
Because I was trying to get this situation behind me. I've been focused on myself and getting my life correct, and making a better life for me.
So someone asking you where you were, you felt like that was an attack?
No, not that specifically, just the whole conversation of that we were having, and the way that you were, coming at me and talking to me. Yes, I did feel like you were attacking me.
Was I talking similarly to how I'm talking right now, asking you these questions?
No, ma'am. You were talking differently.
All right. Let me ask you about your whereabouts during the 21st to the 23rd. You stated that you were where?
I was in Harrisburg, PA.
All right.
Pennsylvania.
And you're certain that you were not in Jacksonville during those dates?
I'm positive, yes, ma'am.
Do you recall seeing IS's sister on Christmas of that year?
No, ma'am.
If SS said that she saw you on Christmas of that year, would that be incorrect?
Yes, that would be incorrect. She would be lying.
One moment. Mr. Humphrey, outside of the female detective that came to your job, have you ever been contacted by police at all as it relates to your involvement in this case?
No, ma'am.
Has anyone ever followed up with you as it relates to your whereabouts around that time?
No, ma'am.
Did you ever provide confirmation of your whereabouts to police for your time period of the 18th through the 28th that you gave us today?
Repeat your question?
Did you ever provide confirmation of your whereabouts to police from the dates that you provided, December 18th through the 28th?
At the time that they had asked me, or prior to like recent?
Yes, did you ever provide it to police?
When exactly are you asking that I provide this information?
Did you ever provide that information to police is the question.
No, ma'am.
Okay. Did they ever follow up with you to try and obtain that information from you?
No, ma'am.
Okay. Recently, you provided this information to the state attorney's office, correct?
Yes, ma'am.
Okay. And that is not a bus ticket, is it?
It is a bus ticket.
Does it verify that you actually got on the bus?
Does it verify I got on the bus? I did get on the bus. I did.
The question is, does that ticket that you provided to the state attorney's office verify that you got on the bus?
Yes.
Does it state on there that you actually used that bus ticket?
No. I'm trying to understand what you're saying.
Just asking, other than you stating that you left, is there any independent verification that you actually got on a bus and went to Pennsylvania?
I went to Pennsylvania.
And let me ask it again. Is there any verification of that you have?
That I have.
Objection, Your Honor. Ask and answer.
Your Honor, he did not answer that question.
I think he's answered it, but I'll overrule it. He can answer this one last time, and we'll put the issue to bed. So you can.
I'm asking about verification. I'm sorry, Judge. I thought you were done.
No, it's fine. I was going to say if you needed to repeat your question or if he remembered the question.
Of course.
I don't remember at this point. So why don't you go ahead and re-ask the question, and we'll see what the answer is, and we'll go from there.
Yes, I'm not asking whether you say you're in there. I said if there is any independent verification of that you have.
I mean, whenever I scan my phone for the ticket to get on the bus, yes.
All right. And you've provided that information to the state attorney?
Already, yes.
And that was just a couple of weeks ago?
Yes.
When this was asked of you about last month, you said differently, though, correct?
When I talked to you? Yes. When I talked to you, I did say differently.
Just a moment.
Good morning, Mr. Humphrey.
Sam, do you want a glass of water?
Good morning.
Okay. Okay. Go ahead. I just want to check on the juror. You're fine. Go ahead, State.
Yes, sir. Thank you. Now, Mr. Humphrey, counsel didn't bring it up, but did you talk to the news about this case?
Yes, sir.
In fact, after IS went missing, you went on camera, did you not, sir?
Yes, sir.
And you told the news that you were hoping for anyone out there to provide information, correct, sir?
Yes, sir.
You're being a good neighbor, weren't you, sir?
Yes, sir.
Trying to help find IS, correct, sir?
Yes, sir.
You knew her from before, your encounter before, correct?
Yes, sir.
Cooperating, putting your face on camera, you agree with that, sir?
Yes, sir.
In fact, when you spoke to the news, you pleaded for anyone to come forward for information, correct?
Yes, sir.
And you did that, obviously, after she disappeared. You agree with that?
Yes, sir.
And sometime later after she disappeared, I think the jury's already heard it's been some days before there was heavy media coverage, you willingly agreed to do that, right, sir?
Yes, sir.
Right. It wasn't until the deposition with Miss Michelle is when you started getting, you were misrepresenting things, correct, sir?
Sir.
You didn't hit it off with her, did you?
No, sir.
All right. Now, Mr. Humphrey, did you have anything whatsoever to do about the disappearance of IS at all?
No, sir.
Now, these dates that we were talking about, you in fact were gone from December 18 of 2018 through December 28th of 2018, correct?
Yes, sir.
In fact, after that deposition, you went and pulled off your phone the exact dates and times of when you left town and when you returned, correct, sir?
Yes, sir.
And you provided it to our office, did you not, sir?
Yes, sir.
You apologized for misrepresenting yourself in that deposition, did you not, sir?
Yes, sir.
Sir, were you in Harrisburg, Pennsylvania from December 18th to December 28th of 2018?
Yes, sir.
Do you even recall sitting here today what times you got on and off the bus?
No, sir, I don't.
Requested, I'm sorry, Your Honor.
He has to come forward.
Oh, I'm sorry. I'm sorry.
You're fine. Just so the record, the juror asked me what you said as you went away from the microphone, Mr. Skinner. I told him you asked me permission to approach the witness.
Okay.
Sir, is this the information that you provided the state attorney's office?
Yes, sir.
Did you pull that information off of your phone?
Yes, sir.
Is that from your records?
Yes, sir.
Will you tell us exactly what time you left Jacksonville, Florida on a Greyhound bus on December 18 of 2018?
It says leaving. I left from Jacksonville, Florida on December 18th, 5:30 p.m.
And what time did you arrive to Harrisburg, Pennsylvania?
Hold on. One o'clock p.m.
Was that the next day on December 19 of 2018?
Yes, sir.
And what was the date of your return trip from Harris, Pennsylvania back to Jacksonville?
December 27th to December 28th.
You departed Harrisburg, Pennsylvania on December 27, 2018 at what time, sir?
4:20 p.m.
And at what time did you arrive back in Jacksonville on December 28 of 2018?
1 o'clock p.m.
Thank you, sir. Your Honor, request to admit the next numbered exhibit, I think is State 68. I have marked it as State Exhibit Triple P for identification purpose and request to admit.
Any objection? No objection, Your Honor. Without objection, mark as State 68.
Nothing further, Your Honor. Thank you.
Mr. Humphrey, take a second. Go ahead. You ready?
Yes, ma'am.
All righty. Mr. Humphrey, you provided that information of that ticket to the state attorney's office a few weeks ago, correct?
Yes, ma'am.
So shortly after our deposition, right?
Yes, ma'am.
All right. During that deposition, do you recall consulting your own calendar and telling us the dates of December 21st through 23rd?
Again, you were very aggressive with me when we had the deposition. So I did and mess up with that deposition. Yes, I did.
Did you tell us that you were consulting your calendar at that time and verified that the dates you were out of town were December 21st through the 23rd?
I lied about the dates to you when we had our deposition, and I came forth and told the truth afterwards.
You also lied about whether or not you even had a sexual relationship with IS during that same deposition, correct?
Yes, because I felt like you were attacking me and trying to incriminate me at the time. Yes, ma'am.
You, in fact, had been charged and pled to this charge of that we're talking about from March of 2018, have you not?
I pled guilty to a battery charge, battery felony, and as a part of my plea was to take the stand.
Part of your plea was to come here and testify.
Yes, ma'am.
And is that part of the reason why it wasn't a lewd and lascivious battery charge as it was originally?
Repeat your question.
Is that part of the reason why it was dropped down from a lewd and lascivious battery charge to felony battery?
I'm not sure.
That negotiation that you made, that was between you and your attorneys, correct?
Correct.
And you're on probation right now
Yes, I am.
for that charge.
Yes, I am.
And yet,
A few weeks ago, you denied having any sexual relationship with her and said it was false allegations.
Indeed, because of, like I said previous, when we were having our deposition, you were very aggressive, and the words that you were using, I did not comprehend. So, yes, I felt like you were attacking me at the moment, and that's how I handled that situation.
The question of did you have a sexual relationship with IS you consider to be an attack,
Yes,
and that caused you to lie.
yes,
And the where you were on December 19th and 20th, that was an attack.
What do you mean that was a
question
Yes,
that
you were.
was
I felt
asked.
the way that you were asking me those questions and talking to me, I felt like you were attacking me as you
That
were
made you
asking
lie.
those
Sorry.
questions. I'm sorry, I didn't mean to cut you off.
No, I cut you off. Go ahead. Go ahead.
No, I'm not, like I said, you were attacking me at that time. Yes, ma'am. Go ahead.
And that made you lie.
Yes, ma'am. I was under pressure.
Nothing further.
Mr. Humphrey, good to see you, sir.
That's it.
That's it? Ms. Michelle, Mr. Davis, you can call your next witness.
Defense, Russ.
Members of the jury, it's 10:35. I need to talk with the attorneys outside your presence to determine our next steps. I have a couple options, just to be transparent with you guys as to what I'm thinking next. I may merge the mid-morning break and our lunch break and make it just an extended time. It depends what's next. I don't know. Do you guys mind just stepping into the jury room for about 5 minutes? I'll have more information. That way I can let you guys know what's going on. Please remember, don't discuss the case among yourselves or each other. Jury's outside our presence. I still have counsel for the state defense. Mr. Quiles present. You guys may have a seat. State, do you have a rebuttal case? Okay, so you're ready for closings then?
Yes, sir.
Okay, what I'm thinking of doing is I got to give them a break, and there's reasons for that I don't want to put on the record, but I got to give them a break. It's nothing important, just for the jury's jury needs a break. What I'm thinking of doing is just giving them like an hour and a half break. Come back maybe just after noon. I know that's an early lunch for a lot of people. I get that. I'm not sure coming back in 20 minutes or 30 minutes and going for an hour and a half is a good idea either, because then I still got to give them a lunch break. But if we start, let's say I start closing at 12:15, that's just over an hour and a half break for the jury, and go straight through. I'll charge them tonight. And they can start deliberations. They say they said yes, or they can stay later tonight. And I'll tell them when I charge them that we are here as late as you want us to be here. Whatever you guys want to do, as soon as you guys want to break, we can come back tomorrow morning. That way they'll have all day tomorrow without having me have to charge them or do closings tomorrow. But I think we should be able to fit all the closings in this afternoon. Is everyone okay with that schedule?
State is.
Yes, sir.
And I would still give the jury breaks after state's first close, the defense closing, and then go to the state's rebuttal closing, and then I would charge them at that point straight, because the rebuttal closing the charge should not be that lengthy. And we can come back earlier to complete the charge conference. They come back at 11:45. We can complete that together. I'll give you guys I'm happy to do it now or at the latter part of the lunch break.
Do it now, Judge.
Okay, that's fine. If you guys are okay with it, I'll just let Mr. Gray know that the jury's free till 12:15. Okay, so the staff can let the jury know that they are on a break till 12:15, and then we'll come back out and recommence. Mr. Davis, at this point, are there any motions that you wish to make, given the close of your case?
Judge, we would renew our motion for judgment of acquittal and rely on our prior argument, case law cited.
Anything the state wants to add?
Just to reiterate our argument, as well as noting that the only attack of any of the confessions that we just heard was from Damian Hatch, not the wire, not Joseph Quiles. And with respect to the other two witnesses, Your Honor, our position is it doesn't change our argument to the court on the corpus delicti issue. We ask you to deny.
The motions are denied. All right, let's go towards the jury instructions, if we don't mind. And I would ask that you guys work off the copy that was emailed out this morning. Mr. Davis, Mr. Michelle, do you guys have copies of it?
Pulling it up now, Judge.
Okay.
For whatever reason, we keep getting bounced off the internet. That's why we keep losing everything. Yes, sir, Your Honor.
Okay, so you have introduction to homicide. That's rather standard. Murder in the first degree. Everything seems rather standard, and then they have the further findings with the firearm. Any objection from the defense in that regard?
Are you at the introduction to homicide?
Introduction to homicide and the first degree murder charge.
No objection.
Your Honor, in regards to the second paragraph under introduction to homicide, should we take out the comma after second degree before murder?
Yes. And after second degree murder, doesn't need to be a comma there. And after manslaughter. I'm sorry, ma'am. You're right. I'm making the corrections on my copy, so that's just grammatical issues. I'm taking out commas in one of the paragraphs. It's not a noteworthy issue. How about the murder in the first degree as to count one? Any objection from the parties as to that instruction as provided?
Not from the defense, Your Honor.
8.
No, Your Honor.
All right, then we have count 2, murder in the first degree. Anything from the defense? Any objection?
No objection, Your Honor.
I'm fixing some grammatical issue and spacing issues. I will email this out again to everybody as well.
Yes, sir, Your Honor. Probably seeing the same thing.
Okay, then we go into the lesser included crimes. Is either party requesting any additional lessers other than second degree murder and manslaughter as to counts 1 or 2?
No, Your Honor.
Defense.
No, Your Honor.
Mr. Davis, is that an issue that you guys have talked to Mr. Quiles about?
Not right.
Can we just have a few minutes to talk to just explain?
Of course, yes. You guys ready?
Yes, sir, Your Honor.
Okay, so I think we left off with whether the defendant was in agreement with no additional lessers for counts 1 and 2, being that the only ones we're addressing are second-degree murder and manslaughter.
Correct, Your Honor.
And?
I'm sorry. We are in agreement, Judge, and speaking with him, he agrees.
So per the standard instructions, second degree and manslaughter are both category 1 offenses. Since one party is requesting it, I'm required to give it. And it sounds like the state's requesting that?
Yes, sir, Your Honor.
Okay, so everything else, there's a category 2, which is a permissive one, and it has to be contained in the elements of the indictment or information that meet the facts of the case. And am I correct in saying that nobody's requesting any other additional category 2s for counts 1 and 2?
Correct, Your Honor, can speak.
Okay. So, guys, take a look at the lesser included charge instruction for count 1. After I tell them that second degree murder and manslaughter are lesser included crimes for first degree murder, I'm thinking of telling the jury the following instruction, but because since we're combining the instruction for second degree murder and manslaughter to make for simplicity reasons, and tell me what you guys think of this. The instructions for second-degree murder and manslaughter as lesser-included crimes for first-degree murder are combined into one instruction for simplicity purposes. The only difference is the name of the victim and the elements of the crime.
I'm going to state, Your Honor.
And obviously, it will be sent out to you guys. Once you read it on paper, if you have any issues with it, we can talk about it as well.
Yes, sir.
The only thing I'm trying to let the jury know is, and I'm sure you guys saw it on the paper, I tried to spell it out as easily as I could. I even spelled it out in the further finding for discharge and causing great bodily harm, that as to count 1, it's to IS, as to count 2, it's the unborn child. And I'll tell the jury that, and the verdict form obviously will spell that out as well. There should not be any confusion that 2 different victims, 2 different elements, not combined into one element. If that makes sense. And I think the instructions clearly set that out. Okay. So for now, second-degree murder, defense, any objection to how it's presented to the jury?
No, Your Honor.
State?
No, Your Honor.
And you guys see how I spaced out how as to count 1, it's IS, as to count 2, it's the unborn child, and that's as to count 1 and 3 as second-degree murder. Then moving on to manslaughter, same thing for count 1 and for count 2 in that case, where the name of the victim is different, but everything else is the same. Any objection to the second-degree murder or manslaughter instruction?
No, Your Honor.
Okay, now we're going to the sexual battery charge in count 3. Any objection from the defense to that instruction as proposed?
No, Your Honor.
All right, in state?
No, Your Honor.
Okay, now we're on the lesser. State, you're requesting lewd or lascivious battery?
Yes, Judge, and there actually is a potential issue with that. As I was looking back, we might have to put something further. Since we're allowed to put on a more occasion, and a jury could convict for one occasion during that time frame, might also be a couple of different time frames. I believe that the evidence supports that the relationship occurred before and after IS was 16. Therefore, lewd or lascivious battery is only up to 15 years old, in 363 or 364, the day before their 16th birthday. So, in order for them to be able to have if their verdict was a lesser included of lewd or lascivious battery, I think we would have to ask maybe for a further finding. I'll talk to Mr. Skinner some more about it during the break. That they believe the date during that time frame would have been before her 16th birthday.
Wouldn't that be the finding by the verdict in that regard?
So that's why this, I know that there's been some issues in the past, so it's been a while since I was in sex crimes.
No, but I think the verdict would spell that out. If they're finding lewd and lascivious, they're finding that something occurred prior to her turning 16, not after she turned 16.
I understand, Judge, and I just wanted to bring it to the attention since I had seen it, and it's just been a while since I did sex crimes, and it didn't come to my mind until I'm actually looking at. I can look at that as well as a break.
Okay. Okay, but the sexual battery charge, everyone's agreeing with that instruction as proposed.
Yes, Your Honor.
Okay, then the lesser for lewd, that's a category 2. There are no category 1s for what's charged in the indictment. Defense, do you agree that as a category 2, even though it's permissive, given the elements of the crime and the facts of this case, the state is entitled to request it be on the verdict form in this case?
Sorry, I didn't catch the last part.
Does the defense agree that even though it's a category 2 and it's permissive, that the facts of this case, given the facts of this case and what's charged in the indictment, the state's allowed to request this charge be read to the jury as a lesser to count 3?
Yes, that's correct. There's a typo about halfway down where it says neither IS is lack of.
Oh, for chastity?
Yes, sir.
Okay, I fixed that. Any, other than what the state mentioned regarding what they're going to further research, any objection to the lewd charge as proposed?
No, Your Honor.
Okay, so for data crime, the one thing I fixed here last night was that I think the state had count 3, the dates wrong per what was in the indictment. I fixed that. Other than that, data crime is rather routine, venue's routine, plea of not guilty, reasonable doubt and burden of proof is routine. I sent you additional instructions for the Williams rule instruction. Have you guys read that this morning? And let me know if you're in agreement with how I'm phrasing it. I'll fix the grammatical errors. And what I did was I took that directly from what I told the jury during the course of the trial. That's the exact language I used because I wrote it down in my notes.
The state agrees.
What I tried to do was basically specifically tell them what this is regarding, so there was no confusion as to it. The general instruction is kind of vague because you may not have multiple Williams rule witnesses. Defense, are you in agreement with it as phrased?
Yes, sir, Your Honor.
Okay, then weighing the evidence, out of the 10 ones, which ones does the parties believe are not applicable to this case? I would say number 10 is not applicable for sure.
The state agrees.
Defense?
We agree number 10 doesn't apply.
Okay. I think number 9 regarding felony or misdemeanor involving dishonesty is appropriate. Number 8 regarding inconsistent testimony is fine. Number 6 is preferred treatment. There's been allegations via cross or direct, so I'll leave it as is. Number 7, I don't think it hurts to include it in there, but I'll defer to you guys.
We would ask just for it to remain.
State, are you okay with it?
No objection.
Okay. So then I'll allow the accomplice and informant instruction to be given. Are you guys in agreement with that?
Yes, sir.
State?
Yes, sir.
And then child witness. I don't think that's really necessary given the age of the witnesses in this case.
Correct. They're all adults now.
The state
Okay.
agrees.
I'll take that out. I'll delete the instruction regarding if he testifies. Now I'll give the instruction regarding him not testifying.
Yes, sir.
The instruction regarding his statements. Is the defense want that included?
Yes, please.
State, are you in agreement with that?
That's fine, Judge. We agree.
I usually see it for like a police interview or something, which is not really what we have here, but
There was one Detective Abbott talked to him at his house.
That's correct. Okay, that's fine. Rules for deliberation. The only thing I think we need to change is, and I highlighted in red, was in paragraph 5, where it says the judge's job to determine a proper sentence. That is technically true, but given what they've heard in this case during jury selection, that's not exactly what's going to happen potentially. I'm fine with deleting it, or tell them at this point you are not to consider any issue regarding sentencing, or just deleting it. That way, it's not even that's why it's not even an issue in their mind. They're aware of everything given jury selection. That's not a secret to them at this
I
point.
was going to say, we kind of harped on it for 3.5 days.
So I'm fine just deleting it. That way, it's not even bringing their attention to the issue.
State agrees.
Defense would agree.
Okay. Cautionary instruction, verdict form, single defendant, multiple counts. Submit the case to the jury. Okay, I'll email this out to you guys. Please let me know if you have any issues with it over the break. And the verdict forms that the state proposed, the only addition I made is that in the caption I put, instead of just putting verdict 1, verdict 2, I put verdict count 1, verdict count 2. Everything else seemed rather standard with the verdict forms. I fixed some formatting issues, and and spacing issues. I'm happy to send those out to the parties as well. But given the substance of the verdict forms defense, did you have any objection?
No, Your Honor.
State.
No, Your Honor.
Okay, I will email this out as well for copies. Other than that, anything else we need to handle? The state, if you can, I just need a copy. My copy will go back with the jury. Whatever else you guys want for your own self is fine. I just need one copy and one copy of the verdict forms.
Yes, sir, Your Honor.
And I'll stable the verdict forms together myself. Don't worry about that. Anything else we need to handle?
No, Your Honor.
No, Your Honor.
Well, yes, sir, very brief. The one email the court just sent, is that the one you want to copy? That was the final?
I sent 2 emails just now, one being the verdict form, one being the verdict forms, one being the jury instructions. The verdict forms seem fine to me. They're spaced out, which is fine. If you guys have any issues about it over the break, just let me know.
Yes, sir, Your Honor.
Yes, sir.
Anything else we need to handle before we take a break from the state's perspective,
No, Your Honor.
defense perspective?
No, Your Honor.
Say how long you're going to need in total for your closings, now that you've thought about it overnight and here you are.
Judge, the state believes it can complete both closings under a 2.5-hour time period.
2.5 hour?
Complete both.
2.5?
Yes, sir.
How much time are you reserving for your rebuttal?
45 minutes.
That's a long time. Not the 45, but
It's
2.5.
A lot of evidence, Your Honor.
Hopefully I will be.
I'll say this, I'm not sure I've kept them sitting there longer. If I've kept them sitting there longer than an hour 45, it's been maybe once or twice. So you're pushing it an hour 45.
So I don't want to be up there an hour 45, Your Honor.
Well, I'm taking the math of 45, 2.5 minus 45 minutes is an hour 45.
We're viewing that as somewhat of like, I believe we can accomplish both under a 2.5 hour time period.
No, because I'm looking at I have streamlined a lot and just trying to focus on certain points. Some things I'm not even talking about.
Ms. Michelle, Mr. Davis, is 2.5 hours sufficient for you guys?
That's more. We will need to judge way more.
I say that because I give equal time.
I understand that we're not going to do 2.5 hours.
If I can charge them tonight, I will. They said they can stay later. And what I would do, and I think I mentioned this earlier if I didn't, is that I'll tell them at the front end, we're here as long as you want us to be here. If you guys want to break and want to come back tomorrow morning, we come back. The only issue is once I charge them, I'm dismissing the alternates. They've been great. We haven't had any issues. Hopefully the 12 come back tomorrow morning. Otherwise, we may have an issue and have one to call one of the alternates to come back. They'll still be under court order. I have instructions. I'll read them for the alternates to dismiss them, and my office will be in touch with them if we need a phase 2. Just letting you guys know that. If I can charge them at 4:30, I'll do so.
And the state agrees, Your Honor, and the court wants to inquire of them whether they want to have, you can tell them it'll take 20, 30 minutes to read if they want to have that read in the morning. However the court does it, the state's in agreement with it. I don't anticipate, Judge, of the closings, but if we're running past 5, I do not anticipate that. But if it is, we all know in that hour of the day how we observe.
No, if at that point in the day, I can read the room. But if it's before then, if it's 4:30, even 4:15, 4:30-ish, no, if they agree that they can stay later today, let the jury do their work, and I'll tell them on the front end, after I charge them, we are here as long as you want us to be here. If you guys want to go home and have a break and then come back tomorrow, you let us know. If you want us to order you dinner, I will order you dinner. Whatever you guys want, we will do. And that way, they don't feel any pressure. There's no time constraints. It's whatever they want on their timeline. And I'll be very clear about that, which I think I have been throughout the trial. But I don't think we'll get to 5 o'clock. I mean, if we're starting at 12:15, and you may ask for 2.5, I have a feeling you're going to be a little less than that.
And tomorrow morning, you're planning on starting at 9, not earlier, right?
Correct. They said yesterday they can't start before 9, so I'm going to abide by that.
I just wanted to make sure.
How about we come back around 12:05? That's still an hour for lunch for everybody. Tidy up any issues we need to, and that way at 12:15 we'll be able to go straight into this. I appreciate you guys. I know it's been a long couple weeks. I'll see you guys back at 12:05. let's go on the record. 19 CF 7518, I have counsel with State Defense. Mr. Quiles present. I do have copies of the finalized verdict forms and jury instructions. Now that everyone has seen a finalized copy, are there any objections from the state or from the defense? I'll first go to the state.
Yes, sir, Judge. After thinking over the break about that category 2 lesser on count 3, the lewd, the state is now going to put our position on the record that we believe it should just be not given. We were going to ask that it be struck, and I believe the defense will agree.
Not give the lesser?
We're asking now that the court not give the category 2 lesser of the lewd on count 3.
Okay, well then that changes the jury instructions.
We're asking that it all be struck with respect to any lesser as to that count. Because we believe, Judge, just to put our position on the record, if they believe any of those acts occurred when she's 16, that actually changes the charge to unlawful sexual activity. And then we'd have to define that. They'd have to make findings as to dates.
Okay, I see what you're saying.
And the state's conceding that one date where we'll be arguing there was PVI was backdating the conception date from the December 13th appointment to July 7th. That was when she was 15. So we know we're not going to be able to argue what dates PVI occurred otherwise. So our position is not to give that lesser, to make the jury have to make findings of dates when we won't even be able to argue other than the July 7th date.
It's a category 2, so defense, are you in agreement with not giving it then?
We are, because it would, in speaking with Mr. Skinner, it would create some issues.
Okay, that's fine. So what I'm going to do is I'm just going to remove those 2 pages from the jury instructions. What I do need, though, is a new verdict form for count 3. And I'm fine getting that later on this afternoon during a break. That's not an urgent request. But the jury instructions, though, will then be correct because I just removed those 2 pages. Verdict forms for count 1 and 2 remain the same, and I actually need an amended one for count 3. We'll take care of that at a break, though. Is there anything else we need to take care of prior to the jury coming in first from the state?
Your Honor, may I just check my PowerPoint, make sure those slides are out? And other than that, we're ready.
Anything from the defense perspective?
No, Your Honor.
Okay, and just to be clear, since we're now taking out that lesser, the defendant is in agreement with the lessers for counts 1 and 2, which we talked about, and then not having any lessers for count 3.
Correct.
Okay.
As much as I'd like the lesser for count 3, I think it creates an issue.
Understood.
All good, Your Honor.
But with that, though, your client's in agreement with not having it.
Judge, I actually was speaking with Mr. Skinner. Let me explain to my client why.
Okay.
Judge, we have consulted with our client. He understands it as an agreement.
Mr. Quiles, can you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth? Yes. All right, so you can put your hand down. So you were present the entire time we went over the jury instructions and the verdict forms in this case. Do you have a full understanding as to what's being read to the jury at this point?
Yes.
You understand the charges and any lesser included crimes being read to the jury for all 3 counts of the indictment? Okay, are you in agreement with not having any lesser included charges read to the jury for the sexual battery count 3? And then you're in agreement with second-degree murder and manslaughter with a firearm being read to the jury for counts 1 and 2? Okay, and your attorney's been able to answer all your questions in that regard?
Yes.
Anything else you want me to inquire about?
From the defense, Your Honor.
Okay, before the jury comes in, now I give this instruction in every case I handle. I've sat through the trial. I know the facts of the case very well at this point. If you don't want an attorney or opposing counsel to object during your closing, don't give them a reason to. Stick to the facts of the case. Stick to inferences and arguments that arise from those facts. If you go beyond that and there is an objection, I will sustain it. I will not give the jury the perfunctory rely upon your own memory. I will sustain the objection and I will tell you to move on. So if you don't want a party to object to your closing, don't give them a reason to. That said, please bring the jury back in. Ladies and gentlemen, welcome back. You guys may have a seat. Members of the jury, both the state and the defendant have now rested their respective cases. The attorneys will now present their final arguments to you. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has spoken. Just to kind of give you guys an idea of the schedule, the state will give their closing argument. I will then give you guys a break. After the break, the defense will have a chance to give you their closing argument. After the defense, the state can give their rebuttal. Whether I give you a break after the defense closing or after the state's rebuttal close, I'll see on timing wise. After they're done, I will then charge you on the law in this case. Depending on what time arguments finish, I will charge you tonight and you'll begin deliberations, or I'll charge you tomorrow morning and you'll begin deliberations. If it's before 4:30, and I expect it to be, I will charge you tonight and you'll begin deliberations. However, we'll be here as late as you guys want us to be tonight. We'll leave whenever you guys want us to leave tonight, and we have all day tomorrow, and we'll see what happens. So there's no time constraint. At that point, it's up to you guys. I can order dinner tonight. We'll talk about that later. But if I do charge you towards the end of the business of the afternoon today, we will do whatever you guys want us to do tonight, going into tomorrow. With that said, State, you have the floor.
May it please the court?
Yes, ma'am.
Defense? I forget you're carrying our child, and you're oversensitive. I'll kill you and cry. You're stuck with me until you die. Shot her in the head? No. Heart. She just went into a bag. Several bags? No, 2. Just folded her. You know, adrenaline of strength of 10 men. She was dead. Her body went into a dumpster. I'm hoping the holiday and the rain will help at that landfill. That houses will be built over her by the time anyone realizes. Ladies and gentlemen of the jury, Mr. Skinner and myself, we appreciate the time and attention that you all have given during the trial portion, which I know we are on day 6. It's been long. It's been a lot before you all, and you all are going to be tasked with weighing the evidence that's been presented over the past 6 days, the law that Your Honor will instruct you after closing arguments, and I'll touch upon that in some of it during my closing, and then common sense. And that is when we are going to ask you all, and something you heard all the way back just about 10 days ago. Hold on 1 second. It's not working. Sometimes you have to get just a little closer. What does everyone have to do unanimously? Again, this was brought up even during jury selection. Did a crime occur? Was the defendant the one who committed the crime? And again, we have talked about the law, the evidence, and using your common sense. Now, of course, that is simplified. And I'm about to go over the material elements, because I know Mr. Skinner had talked about that as well during jury selection, that every crime here in the state of Florida has elements. And that is what the state of Florida has to prove beyond every reasonable doubt, are those elements, not additional elements, but those elements. And it also, in this case, we have charged 3 crimes. So we're first going to talk about date and venue. I know throughout the trial you all heard, is that in Duval County, Florida? That is part of the state's requirement to prove that a case occurred here within this jurisdiction. So that is why you all kept hearing, is that in Duval County? That is why. We have 2 different venues. We are stating for counts 1 and 2 that the venue of the murder of Iyana and her unborn child was at Ace Pick-A-Part off of North Main Street. And I have put an image on the screen, which is State 67. Then I'm going to show you some photographs a little bit later on. We believe, and we are going to argue, that the venue then for count 3 involving the sexual battery occurred at the defendant's residence. And I'll talk about that testimony. And that would have been during the time frame, because it's different. So we have December 19th through 20th, 2018 for counts 1 and 2. In count 3, we have a larger range based upon the nature of the case, that charge, specifically the sexual battery. That it occurred on or between, on one or more occasion during December 1st, 2017, and then up through December 20th, 2018. So that is why you all will see the different dates during your jury instructions. So, roadmap. I'm just going to briefly touch upon justifiable excusable homicide, and obviously we don't have attempted homicide in this case, so I apologize for that one. I'm just going to brush through it because it's a standard requirement in your jury instructions, and so I just want to point it out. That's not the case in this one today, ladies and gentlemen. You can look at it, but you can move on, because I submit to you there is no evidence before you all to consider that the murder of Iyana and her unborn child was justified or excused. But again, it's part of the norm requirements, that's why I always like to touch upon it. The elements of our crimes charged, lesser included crimes, and then the evidence that the state is going to argue, we believe, shows the defendant is guilty of these crimes beyond a reasonable doubt. And I apologize, it's an issue with the clicker. So again, when thinking about the evidence, what is not beyond a reasonable doubt? Speculative doubt, imaginary doubt, forced doubt, a mere possible doubt. Those are not reasonable. And if those start to occur, you need to wipe that away, because that is not reasonable doubt. So again, I told you all that we would bring, can you go back just one two minutes? Thank you. So again, this is about the introduction where it's talking about the justifiable, the excusable, and again, I'm going to go through this very quickly. I'm not reading this to you. Again, it's just to address. Again, no evidence of justified or excused. You can just go next couple. All right. So we have 3 crimes charged before you all. And each verdict of each count should not affect the other one. Because we have brought before you 3 charges that involve the same set of facts. So each charge needs to be determined by you all independently of the other. And that is the reason why, and Your Honor will instruct you on this as well. Thank you, sir. So, what does the state of Florida have to prove in murder in the first degree? So I'm just going to touch upon them, and then later on at the end of my presentation, I'm going to show you how we have done that. And what I've done since counts 1 and 2 are identical except for element 1, and that involves who is the victim alleged in that element. So element 1, is IS dead? Is her unborn child dead? Was the death of IS and or her unborn child caused by the criminal acts of the defendant? Was there premeditated killing of IS and her unborn child, meaning that there was premeditated killing? Now, so in thinking about killing with premeditation, there is no time requirement in the state of Florida. When Your Honor instructs you, it's not going to say, has to be 10 minutes, has to be 1 month, has to be 1 year. It could be as simple as a snap of a finger. The person has to have the intent to kill at the time of the killing. But again, so I always want to point that out because sometimes through watching TV, etc., just rely on the law that Your Honor provides. But there is no time requirement in the state of Florida. However, they have to have that intent at the time they kill. And again, this would be some further definitions. So if you all find that the defendant is guilty of count 1 and or 2 as charged, and also lesser included as well regarding a firearm, you would ask then at that point to make a further finding, meaning during the commission of that first-degree murder, did the defendant actually possess and discharge a firearm, actually possess and discharge a firearm with great bodily harm or death, actually possess a firearm, or did not possess a firearm. So that would be a further finding if you found as charged to murder in the first degree, and you would actually ask to do that as well under murder in the second degree, which is a lesser included crime of first degree. And there's another further finding under manslaughter, but we'll get to that. It's a tad different from the further finding if you get to that point, which we believe you all will under counts 1 and 2. Again, now Your Honor is also going to instruct you. You all, if you believe the state of Florida has proven beyond a reasonable doubt, it is to the highest crime that you all should find the defendant guilty for. So what are some of the lesser includeds here? So it's like a building block. It's like that funnel. You start off with the lowest layer, and then the layer comes up like in an opposite triangle. Because when you start out with manslaughter, it's not to the same degree of elements. In fact, it's only 2 elements. It's a different degree of intent. And then you get to second degree. The difference between second degree murder and first degree murder is premeditation. So second degree murder does not require premeditation. So the elements is the same as first-degree murder, dead. Criminal act is the same. But again, it comes down to element 3, that's the difference. First-degree murder, premeditation. And then in second-degree murder, it talks about a depraved mind, demonstrating a disregard for human life. So when an individual decides, I'm going to shoot my gun in a crowd of individuals, not intending to kill one specific person, that could be second-degree murder. Because I intentionally decided I was going to fire that gun. These are some definitions as well that Your Honor instructed you to help you in making your determination. And then like we're talking about that building block, manslaughter is only 2. Again, element 1 is the same, that the individual is dead. And then it's intentionally committed an act or acts that cause the death. Does not require premeditation, does not require that depraved mind. And the further finding, like I stated, that's a tad different, but it's still involving the firearm. In that instance is whether the person carried, displayed, used, threatened to use a firearm, if you all were to find that lesser included crime of manslaughter. Sexual battery. There are 3 elements in regards to sexual battery. That defendant engaged in any act that constituted sexual battery. Sexual battery is the sexual organ of the defendant penetrated or had union with the female genitals of IS. Go back just a second. Thank you. So, in regards to this one, I submit to you 2 is easy. And why? It says IS was 12 years of age or older, younger than 18. There has been 0 dispute that during the 2017 December to December 2018, she was of the age of 15 and 16 years old. Therefore, state has proven beyond reasonable doubt. There's no dispute about her age. Element 3. Again, I submit there is no dispute about element 3. That the defendant was in a familial relationship with her. He was her uncle. So it comes down to, I submit you all, element 1. Whether you all believe that the state of Florida has proven beyond a reasonable doubt the sexual battery, the actual physical act of that penetration. Again, we'll talk about that later. Go ahead. You go ahead. I think there's 3 total. Thank you, sir. So again, these are some of the things that Your Honor is going to instruct you when you're thinking about the witnesses from the stand. Because you can believe all of someone's testimony, some of someone's testimony, or none. That is each of your province of being a fact finder on this jury. Talks about opportunity to see and know things, accurate memory, honest and straightforward with the attorney's questions. I think there's 3 as well. Thank you, Mr. Skinner. Interest in how the case should be decided. Does the testimony agree with other witnesses? Was there an inconsistent statement? So, there was a lot of witnesses that came before you all. I'm not going to stand up here and go through all of them. You all have had 6 days to think about what everyone has stated. You got plenty of time, and then go back and think about also what they stated. But I just kind of wanted to break down who's actually been before you all the past 6 days. Well, family, Kimberly Mobley, Willie Sawyer, we got dad, we got mom, Juanella Haynes, maternal grandmother, Nancy Ware, paternal grandmother, Samaya Sawyer, SS, her sister. And then we got aunts, right? Jametta Mobley, Margie Mobley. And then we know Naomi Mobley, ex-wife of the defendant, and also aunt to IS. We had some friends called. As you all learned, that IS had a very close knit of friends, either from elementary school or middle school. Because again, she was only IS a 10th grader at the time that this happened. Work-related, we have, of course, the Ace Pickle Park situation with Johnathan Lindros Gary Lindros. We've got Billy Brown with All American Garbage at the time. We have Ed Schmalfeld with the Otis Road landfill that we'll talk about. Then we had a series of law enforcement. We had Detective Abbott, the lead homicide detective. We had Detective Lillard at the time, the lead crime scene detective. Detective Lane, who did the Don Quay and the parsley from IS and SS bedroom on India Avenue. Detective Savage, who did the swabbing of those bottles. Detective Bidlick, who was a part of the homicide team that conducted this investigation, and he was the one tasked with putting the wire on and getting that situated with Morris McClendon. Detective Hamilton, she had gone to 2 different locations. She had gone to Ace Pickup Park to look at that GMC Envoy. She also went to the defendant's residence at Trout River Road to get that 9mm firearm. Detective King, he came in from Ocala with his canine, Knox, and he went to Ace Pickup Park. He also went to the landfill several days as well and told us about that and the alerts that Knox had, and we saw photographs as well. Detective Quintana, the purpose of him, ladies and gentlemen, obviously it was very brief when he took the stand, but it was important that we got the state of Florida to get this information out, that when they get records from a company, and they put these records on these platforms like Cellbrite, Oxygen, that those records are not altered. That's important. They're not changed. They are as is at the time the data is received and downloaded. Officer Harris, she was with the Duval County School Board Police. She was the one that assisted with the video surveillance and looking into if anyone had seen or talked to IS from school when she went that fateful day in December 19th, almost 5 years ago. And then we have Detective Porter. She's the one that commenced the JSO aspect of missing persons investigation on December 21st and all the actions that she did. Experts, you heard from Nicholas Kutu regarding the DNA efforts made by JSO. You heard from Dr. Thomas, how she had done a sexual assault kit with IS. The irony of that, ladies and gentlemen, that would be reported in March 2018 involving a neighbor who was 20. And then DNA results just so happened to come back to the defendant and her interior crotch panties. What a surprise. Put it in for a 20-year-old and we get back a 30-something-year-old who's your uncle. The irony. And another thing we also heard that was interesting from Dr. Thomas is that potential injury to the hymen, indicative of prior sexual activity. And then we heard from Laura Draga, just again to state that the firearm operated, and she also made a noteworthy, the firearm was extremely oily, consistent with overcleaning. And then you heard from Dr. Atchu. She was the one that met with IS on December 13th, 2018. And that's when the bomb was about to explode, because there were no more secrets. There were no more hiding. The IS was in fact pregnant. And not just pregnant, but 5 months. It's on. Who's that father? Then we heard about confessions. We'll get into those. Damien Hatch, an inmate. George Jackson, inmate. Cousins with Morris McClendon. And then obviously the defendant's brother, Joseph Quiles. We heard from a bunch of different people regarding records. Nicole Phillips with Navy Federal Credit Union. Jack Brown with Chick-fil-A. Anthony Knitsch with Verizon. Ryan Nestor with the public safety analyst supervisor. Barbara Johnson, who was with the owner of Gun Gallery back at that time. Susan Johnson, the T-Mobile records. And then we heard this morning, actually, from a couple of defense witnesses. So we heard from Kamar Humphrey. Again, Kamar Humphrey was the neighbor. He had sex with IS when she was 15. State of Florida, someone under the age of 16, not equal to, but under the age, cannot consent with someone over the age of 20, equal to 24 and over. And that's what we have here with Kamar Humphrey. We had a 20-year-old and a 15-year-old, and it was illegal. And Ms. Mobley called. Again, following through and trying to protect her daughter. I submit to you that Mr. Humphrey was afraid during that deposition, thinking it was going in some way make him be criminally liable again. There's been zero evidence put before you all. Zero. I submit to you that that would be speculative, forced, imaginary, or mere possible, which all four are not beyond a reasonable doubt. Zero evidence that Kamar Humphrey is involved in this case. And Carol Clipp, a good Samaritan, trying to help. And thankfully we have people like that in our community. But I submit to you all that seeing someone almost at nighttime while you're driving for 5 to 7 seconds, she was just mistaken, but trying to help. Ulysses Dixon, he's a 5-time convicted felon. He's known defendant now for several years, and he has 13 pending charges. And it's just a coincidence. He's charged with human trafficking and sexual battery. So I submit to you all, again, it's up to you all to find if you believe him to be credible or not. Now, physical evidence. We've gone over the witnesses a little bit. We've got the firearm. We've got crime scene photographs. We've got video surveillance from Terry Parker. Cell phone records, either from T-Mobile, Verizon, because we never were able to get IS's phone, as was told to Joseph Quiles. The defendant threw it in a body of water. But we were able to get the defendant's phone and do what's called a cell dump. The Ace pick-apart video, her bank records, Snapchat records, Google location data of the defendant, the Don Quay and the parsley pills, the khaki bra that Miss Mobley identified, the pink bra that Miss Mobley and SS identified, the lips panties that was identified, the Terry Parker book. Now, it's true, ladies and gentlemen. We cannot say 100% that that book came from IS because there was no record at Terry Parker who took that out. And no witnesses stated, I know for a fact. But it was a coincidence. Out of all the high schools, middle schools, elementary schools, all of Duval County, it's a book from Terry Parker High School, the same school where IS was last seen. We've got the rain suit. We've got the sexual assault kit, the Amazon purchase records, the defendant's timesheet, the DNA from that sex kit, and then the wire. Now, this is just an image from Stage 25. Sadly, this is the last time at approximately 11 a.m. on 12/19/2018 that she is seen alive. And we know by looking at that, again, if you see something different, ladies and gentlemen, in any of these photographs, any of those video surveillance, you rely on what you believe you see, if it's different from what I am stating and arguing to you all. She's on the phone. That call, I submit to you all, is not on her Verizon records. And what did we hear from Mr. Knetch? You can go to a third-party app and make a call on that app and it not show up on the Verizon records. And I submit to you all that shows the planning. Don't want to be tracked. Why else use a third-party app when you have a phone? That planning had commenced before she made that phone call, before she left school. The van. This is the van that the defendant was driving during this time frame. This is the van that would fit all the kids. This is State's 21 composite. This is the van that the defendant was driving the day IS went missing. This is the van that had been used to take them to the beach, etc. And oddly enough, that van gets sold 9 days later, when that's the vehicle that your family uses the most. Now, I agree, and we concede, and we understand. That vehicle was processed. Detective Abbott found it. He got his crime scene detective there. They went there. They processed it, and they found nothing. But again, I submit to you the timing. Talk about coincidences. At some point, those coincidences aren't just coincidences. We talked about the venue in regards to count 3. This is our venue locations on our 16th Street and Trout River Road, where the defendant had lived with his ex-wife, Naomi, during the 2017 and 2018 time frame. And next, this is just a screenshot. So I'm going to talk a little bit about the ACE video. You heard that the ACE video is approximately anywhere from 4 to 5 hours off. Do not know exactly if it's 4, 4:15, 4:30, 4:45, or 5. But we believe comfortably that it's between the 4 and 5. So if we see that 12:53:30, that means it's anywhere from 7:53 a.m. to 8:53 a.m. that the defendant is arriving at work on 12/19/18. And what I did, ladies and gentlemen, State of Florida had shown during its case in chief part of a merged document to kind of get an understanding. However, within that same exhibit is the actual individual clips that have the time. So as indicated on my PowerPoint is the time associated with this clip, which is 12:53:30. And this clip is a Channel 8 video. So the next thing we know, and if you'll help put one more time, thank you, sir. I'm now playing 15:17:41. So we are now approximately between 10:17 a.m. and 11:17 a.m. And we see the defendant leaving. Even though he had told Detective Abbott, I never left work that day. Even though he put on his timesheet, that indicates I never left that day. And just happens to be during the time frame that IS leaves school. Again, coincidences adding up. And two, the reason why I was saying about the 4 to 5, because what we know for sure, this is the correct time on the Google location data, where the defendant, if you'll hit play, sir, thank you. We know that between 11:15 and 11:39, that the defendant is going to that parts store location near the airport. And you also heard from Detective Abbott that he drove these locations. He said it was approximately, depending on traffic, between a 7 and 8 minute drive one way from around Ace Pickup Park to the parts store. And then he had stated as well that it was like a 38-minute trip, round trip from Terry Parker High School to the area of Terry Parker. And then he stated that that parts store to Terry Parker High School was approximately 18 minutes one way. Another thing we heard about this is that when the almost 11:40, it's 11:39 and some milliseconds after that, that GPS goes off. As you heard from Ryan Nestor, doesn't come back on until 4:04 p.m. the next day again. A coincidence? I submit no. Because you know what also we heard? We heard from Naomi Mobley, defendant's wife. She said, I went back and looked. We always share locations. During that same time frame, he had turned it off. Again, coincidence? I submit no. Next one, please. So thinking about time, just even in reference to what the actual video shows, at 15:17 and some seconds, the defendant leaves. And we only have a video of that 25-minute time frame. Well, the defendant comes back at 16:30. It's gone an hour and 13 minutes. You can hit play. And also, again, make your own observations, but I submit to you the defendant drives back. He drives back in that new area that Ace Pick-Apart has acquired, where that was the old concrete factory where there's no video surveillance. We submit to you, that is when he takes IS back there. Again, he's gone for an hour and 17 minutes, and that GPS Google data only is for 25. So we have 52 more minutes. Another thing we heard that's important about this time frame, Naomi Mobley stated, defendant didn't come home. I didn't go up there to bring him lunch, and he didn't come home. 52 minutes. Again, coincidence? No. Now, did we hit play? Thank you, sir. Defendant then is back in that area where you've heard from the Lindroses. He's not allowed to drive his vehicle back there. I mean, he works back there, but can't drive his vehicle back there. Now we see him finally coming out from that area with no camera surveillance. Go ahead, the next click. 3 minutes and 39 seconds, approximately, is how long he is back in that prohibited area of his vehicle. Go ahead, sir. Now, at 18:46, so again, if we're doing our math, that would be 6 p.m. if we take off the military time, minus the 4, it's around 2:46. If we do the 5, 1:46. So sometime between 1:46 and 2:46, again, defendant is getting duct tape. Duct tape. Johnathan Lindros was asked, is that something normal for you to have a task to work with? Johnathan Lindros said, no, it's not. And another thing I want to point out to you all, again, if you hear something different, in the wire, defendants asked, were there strings on the bags? The defendant said no. Therefore, submit to you all, a way to get those bags to stay shut, since they have no strings, is duct tape. Now, we know that at the end of the day, the defendant leaves at the 22:06 44-second mark that's indicated. So that would either, again, be around the 5 o'clock area or the 6 o'clock area, between those two time frames. Okay. We know that he comes back to Ace Pick-Apart at 12:44:01. And I know that Mr. Lindros had felt more confident with this date probably being closer to the 5-hour minus time frame. So that would be 7:44 approximately in the morning. Now, another thing I just wanted to point out to you all, again, these coincidences. In the 12:19:18 video, the defendant has braids. Naomi Mobley had stated that he would wear his hair in braids, or he also would wear his hair with no braids. But I submit to you that in 12:19:18, the defendant's wearing braids. However, in 12:20:18, no braids. Coincidence? I submit no. Now, another thing in regards to the video comparisons of 12:19 and 12:20. And again, 12:20, it is raining a lot, pretty heavy. And on this particular day, the only time, and this is also for 12:19, the only time the defendant is seen bring a vehicle from one side where that concrete factory area to the area by the crusher, the area by the container. It's only one time. And that one time is not long before the container arrives. Coincidence? No. That's 1852. Again, it appears to be an older maroon four-door sedan. You'll hit the next one, please. And then, at some point, too, during that day, the defendant gets another rain suit. Submit to you, that's odd. He has a rain suit on. But again, another thing, coincidence? Submit no. And that was just early in the day, and I apologize, it's a little bit out of tune for timing purposes. Then, if you'll hit play, Mr. Skinner, at 1852-53, and I'm going to show you all. It's hard to see in this video because it's covered by parts. However, there is a red blurb right under this red car. That is the edge of the container. I just wanted to point that out. Is it playing, Dan? It's playing now. And in the 1852-53, we're looking at camera angle 11. And in this angle, I'll submit to you all, this is then where we see the defendant bringing that sedan to the area of the container and the car crusher. You'll go to the next one, please. Now, about another 8 to 10 minutes later, the defendant is now in his front loader. Again, he's changed out the forks for the bucket. And Jonathan Lindros even kind of stated, I'm not really sure why he's getting the bucket. Well, in thinking about this at the 1902 approximate time frame, the bucket is actually up. It's not facing forward. So I submit to you, there's something inside that bucket. And this happens shortly after the car is taken. The only car taken in that 2-day time frame. Then, in the next clip, approximate same time frame, at 11, I just did a screenshot, there's video of it. It's taken to the container. And yes, it's the only container on the property, but there's other garbage receptacles closer by. However, this is taken straight to the container. After the container, the bucket, I submit to you all again, you can look at it, is downward. It's not upward. Now, in 1908-34, this is where we submit the All-American garbage has arrived. The defendant is in his front loader, and he goes straight to him. Now, this is after he's brought the car over. This is after he's brought something over in the dumps and the bucket. And I submit to you again that he is actually not walking, but in a hurry to get to that driver. We can move on. I submit to you, you'll see him get back in, and then next, he then will take them to the location of where the container is to swap them out. I submit in the first one is a screenshot from 1912-52, where again, if you look closely, you can see the red container coming down at an angle to actually slide off. You can see that in the video. And then the All-American is clearly displayed at the 1921-05 time frame, exiting the property. Camera view 5 at 1921-32. Is it? The All-American container is seen exiting the property. And it's a state submission that that's when IS is exiting the property. Next, please. Now that time frame, 1921, was when we saw All-American container leaving. 24 minutes later, who do we see leaving? Will you hit play, sir? However, he doesn't go straight out. He goes back. I submit he's going back to make sure he's got everything taken care of. Nothing left. Hit the next, please. And then what do we learn? We learn that he goes to the gun gallery where his ex-wife had identified his signature. And it's on line 10. Now, something else that was kind of interesting about the gun gallery, the GPS Google location data comes up. But what also did we hear? We heard from his ex-wife, they always go to the gun range. So I submit to you, is it a coincidence that you're putting in GPS when you always go somewhere? Submit to you, wouldn't you know the address? Again, coincidence? No. The defendant talks about going to the gun gallery in The Wire to his brother. Somehow thinking that they can figure out this gun's been shot recently, well then I submit to you, our argument is, well, I went to the gun gallery, I just shot it. You saw my Google location data, I went there. Again, coincidence, part of the plan. Timesheet, another not coincidence. That ACE video refutes that timesheet, refutes what he told Detective Abbott back in December of 2018 when he first met him. Refutes. Well, the next question would be, well, why did he then go to a parts store? I submit to you plan B. They find out that I leave. I went to a parts store. Mr. Lindros asked me to go. But then it still doesn't add up. Because we still have 52 minutes unaccounted for with no location data that's been taken off. The gun. The defendant says in The Wire, I used the gun at my house. The police haven't even gone and get it. He even says it's a 9mm firearm. Police go to the house, do a search warrant, they get it. So we submit to you this is our murder weapon. Now the landfill, yes, it was a lot. But that's what JSO did. They were 16 grueling days at that landfill. Did they find her remains? No. But what did we hear? What did we see? And just so you know, the picture on the left is from day 1. The picture on the right is from day 16. What was it? Over 5,500 tons JSO went through. But again, needle in a haystack, looking for her. We saw the vultures, indicative of remains. We had the canine out there, Knox, alerting as well. Again, needle in a haystack. Okay. But we did find some items. Again, we talked about the Terry Parker book. We had the pink bra identified, the lip panties identified, and then we also found some paperwork from Ace Pickle Park during that time frame. Snapchat messages. I just want to point out some of those to you all. Again, we submit those messages are from the defendant and IS. And that IS saved those messages. She was the owner of both accounts. Again, because this is a secret. This is an underage relationship with a niece. This is not something that is wanting to be known. In fact, IS lied until the day she died for him. And what did he do in return? He killed her for her loyalty and love. I'm too jealous with you. I couldn't even sleep last night. I need to separate myself from you. Not yet. I need to calm down. And I put the dates beside them, August 3rd. You know what? I'm going to give you last piece of dick in the AM and cut all ties with you completely. August 7th, 2018. You all and I was getting a divorce, and you and I, once you hit 18, was going to break out. August 7th. I'm not going to have you stay the night anymore. Anyway, so whatever you really did this time, August 7th, 2018, and we know that IS was over there all the time, based upon all the testimony. I love you too. We can't risk your future. I promise I'll give you 2 kids. But you need to finish up college so you can be very successful in life. That's August 14th. You just make it all so easy for me to just leave you alone. Goodbye, Iyana. Just like he did between December 19th and December 20th. I think you should take the bus back home from now on. Again, we heard that the defendant would go to that school, pick her up, pick up SS, and then his son when he came. And that's what we heard from Haley Schimper. She had seen the defendant's van there before. And that's what we're hearing right here as well. You seem to have it all figured out. That's August 20th. I don't like nobody hurting you but me. Who did we also hear that the defendant was quite selfish from? Oh, and that text message from the defendant's phone from Joseph Quiles about the selfishness of his brother. I'm sorry, I forgot. You're carrying our child and you're oversensitive. I do love you very much and don't want you to keep going through this drama, but we have plans, and if you act off your emotions, you will hinder our plans in the future. If that doesn't predicate why we're here today. IS hindered the defendant's plans by not having an abortion. It's very hard to see it now, but it's the truth from August 22nd. Again, for only purposes for count 1 and 2, motive, intent, plan, opportunity, absolute mistake for count 3, and then motive only for count 1 and 2. He also admits to Maya. Now, there's a thing that could potentially, well, when we listen to The Wire, the defendant says 100%, I never messed with SS. Well, I submit to you that's because he's not going to admit to that because she's alive. He's admitting to IS because he thinks he's going to get away with it because he thinks that there's no evidence. He even says that they got nothing on me. They going to find that body. So I submit to you that he lied about SS because she's alive. She's still around. IS is not. That was August the 23rd. August 26th, LOL, you will be my best friend once you're pregnant. I'll cook for you until you can't eat no more. Again, what do we hear from Naomi, his ex-wife, about the cooking? More corroboration. Next, please. I've been kicked down there so much, I'm not sure how you're even pregnant. From August 29th. So that's interesting. By the end of August, the defendant already knew she was pregnant. Because we know the family doesn't find out till December. August. There's still time for that abortion. Yeah, so I need you to be like 100% with me at all times. I'm just so in love with you. I'll kill you. And cry. That's from 3 months before she's killed. You're stuck with me until you die. How prophetic. Because Iyas was. She was stuck with him until her final days on this earth. I love you way too much to let you go, so you're not going to have no life. And she doesn't. Now, in going into just highlight a few of the things of The Wire, I know it was 2 hours long, that's why we just wanted to point out a few things. She was 16 when she came out that she was pregnant. It was a possibility that was mine, you know. They already was accusing me of it. Yeah, she got shot. There ain't no ballistics. No, it was just that I got. Everything's clean. No, nothing. I went to the gun range the same day. Taurus, a 9mm. It was a roller dumpster. That's all they got over there as far for garbage. 40-yard. And that's what we heard is a 40-yard container. Next one. If she had gave birth to that baby, I've been sitting right here with y'all. Adrenaline give you the strength of 10 men. So the same day she went missing, the same day you dumped her? Well, no, it wasn't. It would be the next day. So where the F you had? You have her the first day. She was dead, man. She was dead. It's loud over where I work at. And this was, I submit, in reference to the gunshot and the noise. Again, part of the planning, part of the preparation, part of that premeditation. You did say you were in the yard. Yeah, and I submit to you that's in reference to where he shot her. And yes, ladies and gentlemen, is there some discrepancy? Was it in the car? Was it outside the car? Yes, it is, but it doesn't change where he's at ultimately, which is Ace Pick-Apart in a secluded location. Her name was Iyana. A unique name. She was actually scholarship. She was fixing to graduate 2 years early and go to college. As you heard from Naomi, she was the one that they thought could be president. You think they'll give you... Oh, I'm sorry. I thought I heard something. You think they'll give you the needle? Well, one, that premeditated murder. Two, a young adult with an unborn child that was in 5 months. So they can consider it as like 2. But the only thing that I might have on my side is due to the accumulation of garbage. He's talking about how, well, selfish me. Thank goodness it's the holiday season, so I can get away with this murder even more. This was a holiday. And then with all the rain that we had within those days. You know what I'm saying? Shot her in the head, no. Heart. Yeah, she was dead. She just went into a bath. You poured some water where the blood was? Yeah, no. It's just, it's dirt. You just scoop it up. Effing move it. Scoop it up. Y'all fixing to run away? Yeah. You faking it? Yeah. Boy, you, and then the defendant says, slime boy, and shit. Again, with that planning, that premeditation, using that authority over her, that manipulation over her, that is clearly seen in those Snapchat messages, the mental abuse that he has over her, a juvenile. It's your wife's sister's kid? Yeah. She was my little baby. Yeah, been effing how long? probably maybe a year, or probably less than a year. My theory behind it is that since I had no connection to anything, she can sit there for a whole effing year and they'll build houses on top of that. That's how the defendant sees his niece. Shit. Now, in regards to the brother, his biological brother, we know that there was 4 calls on December 20 based upon the records. He was nervous, panicky, concerned, something I need to do. What is he going to do with the young lady? It's going to ruin his family. The young lady is pregnant. It's his wife's niece. The next call is, took care of that. Had her in the vehicle, strangle her, couldn't stomach it, shot her in the chest. What's also in the chest? The heart. Had her in the, discarded her body, and then transported in that dumpster. Who next? Destroy the vehicle she was in. Well, what did we see in the video surveillance? We saw one vehicle, 19 to the 20th, being taken by the defendant to the crusher. Shot her in the car, in the chest. She came there on the premises that they were going to run away together and be a couple. That manipulation, that love, that loyalty, taking that secret to her grave. How the defendant repaid her. Wrapped her in carpet, used machinery to do it. That front loader, front and center on that video surveillance. Knew the dumpster was going to be picked up, which it was. Would lose his entire family if his baby was born. Because what do we all see here about Naomi? From Naomi, but all his children look just like him. All. And then went to the shooting range. Planning it for months. She wouldn't have that abortion, I submit to you all. That's one of the reasons why I asked Nicholas Q2, did you do fetal remains? Can you do DNA on paternity? And he said they could. When she wouldn't get that abortion, the defendant was left with the choice of killing her and destroying that evidence. Put her phone in the neighboring water, tried to speak with his brother to see if he changed his story. The brother wouldn't speak to him, so that's when he made the decision to call. Why told does not tolerate abusing children and women. So, just kind of getting closer to wrapping up, we also heard about the Don Quay and the parsley, that the defendant had given these to IS and SS, and then Detective Abbott was able to dig into that. He didn't just take the word of Miss Mobley, ISSS. He reached out to Miss Mobley and said, hey, you just checked some accounts to see October of 2017, lo and behold, parsley and Don Quay. And lo and behold, what do we hear? Tissue miscarriages. Now, this is just more specifically in how we proved, and again, coming down here to the wire. Element 1, again, element 1 is the same except for which victim. IS is count 1, unborn child is count 2. Dead. So the reason why the family was called, ladies and gentlemen, and that was to show her world was done. Mom, dad, grandparents, aunts, sister. Nobody has heard from her since she left the high school at 11 a.m. on 12/19. Friends. She's a teenager. Teenagers talk to their friends. That's their life, usually, at that time, is their friends. She never returned to school. She never used another bank charge. She never had another phone communication. She never picked up her checks. Over $150, and it's right before Christmas. A teenager? And then the admissions to the brother, the admissions to the wire, admissions to the hatch. That is why, ladies and gentlemen, we are submitting. We have proven beyond a reasonable doubt, based upon that evidence and the exhibits that corroborate, that IS is not with us. She is dead. And in the defendant's own words, she was dead. Next one. Death was caused by the criminal act. He said he shot her, couldn't stomach it. He was at work, said no cameras. The activities at work regarding the forklift, getting the duct tape, lying about leaving work, turning off the GPS data location between those fateful time frames of 12:19 and 12:20. Cell phone records. His cell dump. He deleted his records from December 2016 through December 20th. Coincidence? No. Container. The landfill. The video from Ace. The timesheet. He didn't go home that day. His actions, because what did Miami Mobley also tell us? Before IS went missing on that 12/19, he was fidgety. He was nervous. He was restless. He wasn't getting sleep because he knew she wasn't having an abortion. Because think about that short time frame. He's known since August that she's pregnant. Mom finds out December 3rd. Family finds out December 6th. Accusations by aunt comes December 6th. Baby's confirmed December 13th. And then Iyana is killed 6 days later. The pressure was on. She turned her phone off. Brother wire hatch Snapchat messages. We submit this shows that he shot her and what he did with her and why he did it. Now, might be a question. I'll just go ahead and just address this very quickly. Well, we don't know if he was the father of the child. Well, ladies and gentlemen, it doesn't matter. There's not one element under murder in the first degree that says we have to provide by DNA that the defendant was the father. That's not one of those elements. Because if we even think about the defendant's own words, it was the chance alone that the defendant killed. The chance alone. So it doesn't matter if that child ultimately was or was not. We submit to it was, but it doesn't matter. That's not one of the elements. And in the defendant's own eyes and own thoughts, his own statements, the chance alone had him commit pre-planned, premeditated murder for his own selfishness so he would not get caught. Next one. And the last one, the premeditation. Again, we've heard planning about a month. We've heard planning months, pressure on the family. Tricked her to come to work. Said he would even kill in Snapchat. The dates, I already talked about the 3rd, the 6th. Cues, the baby confirmed. Not getting an abortion. The omissions, the Snapchat. Now, in regards to the sexual battery, encourage or entice her to have sex. Well, she's pregnant. Common sense lets you know how a pregnancy occurs. We have the Snapchat messages where he talks about, I've been hit so many times down there. You're carrying our child. You've heard SS state it was the defendant too. You've heard the defendant admit that about the sex and the wire and to his brother as well, and to Hatch. The DNA, the hymen, the limited purposes of SS and ID, as well regarding the motive. The grooming. Like he had told ID, she's the new girl on the block. She just came into the picture in 2017. New niece on the block. I've already had 2 nieces. So are you a virgin? Oh, you sure are pretty. Oh. You know how to put a condom on? That's what you need to go further with ID because she didn't allow it. That's the difference. She was older, more mature, different personality than a 13-year-old. All right, next. And at the time, again, so this was another easy one. We talked about age, her date of birth. We heard from mom and sister that she was, thank you, that she was under the age of, it should be 18, I apologize. That should be 18, that's my bad, but we rely on from the law from your honor. She was under the age of 18 at the time. Apologize for that error, it's a big error. Again, the limited purposes, again, and I just touch upon this, is the sexual abuse of SS, and ID for count 1 and 2, motive, and count 3, motive, intent, plan, opportunity, absent mistake, or accident. Okay, next. Now, did a crime occur, and did the defendant commit the crime? I submit to you, ladies and gentlemen, after hearing all this evidence and seeing all the exhibits, yes, the defendant not only committed 1 crime, but 3. And I talked about in opening how there was going to be a lot of different pieces in this case. And after all these pieces were put together, there was going to be a picture. So let's look at those pieces. The DNA from the crotch and the panties. The third confession that was made to Damian Hatch. The second confession that was made in the wire. Sister Samai, because she sadly was there during one of the defendant's sexual abuse acts on her sister. And also saw different various forms of kissing and touching and groping. She's pregnant. Came from having sex. Cell phone records again. Deleted data, turned off location. Go ahead. Iyana as well, too, turning off her phone. The Snapchat messages. Confirming the relationship, the sex, the nature of the father. Go ahead. The gun. Got that. The donkey and the parsley. Again, not wanting to obviously get an underage niece pregnant. The A's video that contradicts the defendant leaving, but corroborates the defendant's omissions. Google location. The defendant leaves, but we still got 52 minutes unaccounted for. And lastly, what started it all, his brother, Joseph Quiles. So, ladies and gentlemen, to go to the next one, we're asking you for Iyana and the unborn child who is going to be named Hazel to find the defendant guilty of premeditated first-degree murder of IS, if she was pregnant with his child, or the chance of being the child, the father of the child. And then also for the unborn child. And we submit to you that the evidence before you is beyond a reasonable doubt, that the sexual battery as well, regarding all the evidence, and find him guilty as charged to all 3 counts. Thank you all.
Members of the jury, I told you I'd give you a break. At the conclusion of the state's first close, I'll do so. It's 1:31. Is 20 minutes enough time? Let's come back at 1:55. We'll go from there. Please remember, don't discuss the case among yourselves or each other. And I'll see you guys then. The jury's outside our presence. You guys may have a seat. I still have counsel of the state defense, Mr. Quiles, present. Anything we need to take up before we come back for the defense close? State. What I'll probably do is do the defense close and then go straight to the state's rebuttal close and then give a break at this point. So I'll see you guys in about 23. Ready to bring the jury back in? Okay, yes, sir. So assuming timing works out, I'll just go straight through, take a break after the state's rebuttal, and then we'll charge them thereafter. Given the hour, I probably will charge them today. All right, let's bring the jury back in, please.
Your Honor, the jury reenters the court.
All right, members of the jury, welcome back. You guys may have a seat. We're going to continue. Now it's the defense's turn for a closing argument, and I'll turn to the defense. Ma'am.
Ladies and gentlemen, I always start every closing the same by saying thank you to you. Thank you for your time. Thank you for your attention. This has been a long, almost 2 weeks. And so I just want to take a moment to say thank you. I don't get another opportunity to say that to you. So again, thank you very much for listening, for paying attention, for being on time, for just being excellent at wading through all of this. Question everything. Question and weigh the evidence that you have observed over the last 6 days of testimony. Question what you've been shown. Question what you've heard. Question everything. Why should you question everything about this case? When you look and start to make the determination of whether or not Mr. Quiles is guilty of first-degree premeditated murder, 2 counts, and the 3rd count of sexual battery, you have to make the determination of whether what you've been told has happened and the way that it happened, if that makes sense. So question, weigh that evidence. Does it make sense to you? Are there holes? Are there things that just don't add up? Are you left with questions that lead to reasonable doubt? Let me talk to you about the charges. We'll start there. The charges are first-degree premeditated murder. You've heard from the state. They've gone through this with you, so I'm not going to spend a whole lot of time going through each of those. But I want to just point this out. State told you, we told you, this has been said many times, that each and every element of these crimes has to be proven to each of you beyond and to the exclusion of every reasonable doubt. That's a high standard. That burden of proof lies with the state. They have to prove each of these elements to you in order for you to be able to find Mr. Quiles guilty of anything. The state mentioned some lesser included as it relates to the first 2 counts. You have the option of determining a second-degree murder as a lesser included or manslaughter. And Ms. French did a great job of explaining those differences to you. I'm not saying anything different. The difference between first and second degree is that premeditation, and the judge will instruct you on those details in full at the very end once the state has had their chance to rebut. Listen to those instructions. Think that through. Think through the premeditation portion. Think through what second-degree murder might mean for you if you do not find, beyond and to the exclusion of every reasonable doubt, that there was premeditation in this crime that they have alleged. Count 3 is sexual battery. Again, this has already been gone through, so I'm not going to spend a whole lot of time. But again, you must find that each and every element has been proven beyond and to the exclusion of every reasonable doubt. So what is reasonable doubt? You were told what it's not, so let me tell you what it is. If after carefully considering and comparing and weighing that evidence, questioning what you've heard, if there is not an abiding conviction of guilt, or if you have that conviction, but it's not stable, if it wavers, if it vacillates, it's not something that you feel is an abiding conviction, that is not a thing that you can find guilty. You must find him not guilty. That would be reasonable doubt. And if you find that there is reasonable doubt, if you are wavering back and forth, if you're not sure, if you're left with those questions that lead to that reasonable doubt in the end, you must find Mr. Quiles not guilty. Now, where can you find reasonable doubt? In what you've heard. The evidence, conflicts in the evidence, the lack of evidence. I submit to you that all three will lead to reasonable doubt in this case. There are conflicts left and right. There are inconsistent statements. There are things that just don't make sense. That is what will lead you to reasonable doubt. We told you at the very beginning that Mr. Quiles was carrying something with him when he walked into this courtroom that very first day of jury selection. We said then, you must presume, you have to presume that he is innocent. And that has stayed with him through every stage of this trial. He is innocent until it's proven beyond and to the exclusion of every reasonable doubt as to every material allegation in the indictment. And that's counts 1, 2, and 3. If that has not been overcome, he is not guilty. Weighing the evidence. This is what you're tasked with. This is what I started off talking with. This is your duty. This is what you have to do. You have to weigh the evidence. It's you. Mr. Davis told you in his opening, you all are the triers of fact. You all determine who's telling the truth and who's not. Just because the state says it so doesn't make it so. It's you all. You all get to decide what evidence is reliable, what evidence should be considered by you, what is the best evidence that's come up. And you heard a few of those things that you can consider when you're weighing the evidence. And those questions that you should ask yourself as you think through the evidence. And I'm going to read a few of them. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering our questions? Was the witness honest? Did that witness have some interest in how this case should be decided? You heard from people who had things to benefit from sitting on that stand and talking to you. Weigh that evidence. Determine if it's credible or not. Determine if that's something you can rely upon. Does the witness's testimony agree with other testimony and other evidence in the case? And finally, did the witness at some other point make a statement that's inconsistent with the testimony that was given in court? I would submit to you that several witnesses changed what was said from before to now and in between. Inconsistencies, this case is rife with them. Who did you hear from? I didn't know that Ms. French was going to do this, but I did a very similar slide of who the family is, just so you could get an idea of the players, who came to talk to you. And to refresh your memory, because I know it's been some time since you've heard from, especially from the very first day, of the people that you heard from that day. So let's go through a few of the things that you heard and give you a few reminders. You heard from the family of IS. You heard from Kimberly Mobley. You heard from Willie Sawyer, mother and father of IS. You heard from Jametta, Margie, and Naomi. Those are aunts. You heard from SS, IS's sister, ID, IS's cousin, and you heard from grandmothers, Winella Haynes and Nancy Ware. One's a maternal, one's the paternal grandmother. The paternal grandmother is the one that lived in Georgia. What did you hear from them that sticks out? What did you hear from them that needs to be considered as you weigh the evidence and make your determination? You heard from Naomi Mobley, Mr. Quiles' ex-wife, and that was just yesterday. She told you that December 6th, the family got into a huge argument about Johnathan Quiles being Jose. She told you that she had heard these rumors among the sisters. It's 5 sisters. It's a lot of girls. That comes with talk. Those sisters started those rumors in early 2018 when Kamar Humphrey sexually battered IS. She told you, Naomi Mobley told you, she confronted her nieces. She said, I went to both of them. I didn't just go to one, I went to both. And I went to them away from Mr. Quiles. They spent a lot of time with her. They were close. She asked them, has there been anything inappropriate, anything of a sexual nature, anything whatsoever at all? They both told her, no, never. He would never do anything like that. Mr. Quiles wasn't around when those denials happened. Mr. Quiles didn't influence that in some way. That was a conversation between an aunt and nieces. And what happened after that? After those accusations first came up in early 2018, did IS, SS, and their 2 younger brothers stop going to the Quiles home? No. They continued to go to their house. If those rumors had been around and there was any truth to them, if there was any indication that that was actually happening, those children would not have been at Naomi and Uncle John's house. Naomi Mobley herself said she would have taken her child and left him. Those rumors were put to bed because there was no truth in them. Why? Why would Kimberly Mobley continue to allow her children to go to Mr. Quiles' home if she suspected that there was some sexual activity going on, if this rumor had any truth to it whatsoever? Why would Naomi Mobley stay with Mr. Quiles if there was even a modicum of truth to those allegations? I would submit to you that the answer to both of those is no, they wouldn't. She would not have. Those kids would not have continued to go there. Let's talk about the Snapchat. Naomi Mobley told you yesterday she knew Mr. Quiles would communicate from time to time with the children on Snapchat. There was no secret. That wasn't something that was being hidden. If he's on the phone, she says, what are you doing? He said, oh, I'm Snapchatting my niece, Snapchatting so-and-so. or whatever he was doing. He wasn't hiding that from her because there was nothing to hide. What did you hear from SS? She maintained for years after her sister went missing that Mr. Quiles never sent anything on Snapchat that was inappropriate. Just normal conversation. These messages that we saw, we don't know who wrote these messages. We can see that there are messages that are about Mr. Quiles, not from him. We don't know who set that account up, who was using that account regularly, how many people were using that account, who had access to that account. It's a one-sided conversation of some saved messages. The context is not there. It's not complete. You don't know who is on the other end. There are messages contained within there that could be from anyone she was in a relationship with. So who else was she in a relationship with during that time? We've heard from her best friend that she was in love with Kamar Humphrey. She was in love with Jose. That relationship with Kamar went on for months. Her best friend from kindergarten told you that. Jose, she was in a relationship with for quite some time. What did the friends of IS tell you? Albertha Vey, she came and she talked to you all. What did she tell you about Jose, IS's boyfriend? She told you he was Hispanic and black. He was 20 or 21 years old. He lived in Azalea Ridge Apartments. Same apartments that Willie Sawyer, IS's dad, lived in at the time. And she had talked to SS the day that IS went missing and told her, hey, maybe tell your mom about Jose. What did SS say back to her? I don't know what you're talking about. SS didn't know anything about Jose. And what was the last thing that Albertha Vey told you all? She had heard that IS was seen in Azalea Ridge Apartments. What did Willie Sawyer say? Willie Sawyer told you that he heard Jose was there. He let police know. They didn't follow up. They didn't investigate it properly. What did Haley Shempert, the best friend from kindergarten, tell you? She told you about being in love with both Jose and Kamar Humphrey. She also told you Jose wasn't a code name. That was his real name. Albertha told you the same thing. She asked her and said, oh no, Jose is his real name. There were officers who were involved. I'm going to go through a few of those as well. You heard from Detective Porter. Detective Porter went to Mr. Humphrey's job to ask him where he was during the time that IS went missing. He told her that he was in Pennsylvania. They never verified that. They went off of that and they left it there. It wasn't until just a few weeks ago that he provided a bus ticket that shows he was supposed to go to Pennsylvania. But guess what? When I asked him about this, I didn't prompt him. I didn't ask him, oh, were you there from the 18th to the 28th, or were you not there during those days? I said, when did you go out of town? He told me, I was gone from December 21st to the 23rd, and I went there by plane. What aggressive question could possibly cause you to lie like that? Where were you? That's what I asked him. I didn't force him to say that. I didn't badger him. I didn't ask him 10, 12 questions and then get him to trip up and say another date. He volunteered that information. In fact, what he said was, let me check my calendar. He checked his calendar and told us the dates that he was gone was December 21st through the 23rd. Only later, after realizing, oh shoot, let the cat out of the bag, I was in town on the 19th and the 20th, did he go back and produce this bus ticket to show that he wasn't in town. 4.5 years later. The other thing Detective Porter did was try to follow up on some of those leads. Later, once the family finally fesses up to Jose being something that they knew about earlier, Detective Porter asked, hey, why would you not disclose that information to me earlier? Why are you just telling me that now? She asked SS that, because SS was the only one who could say that Jose could possibly be someone else. She was the only source, the only witness who says that she knows that Jose is Johnathan Quiles. But think what she told Albertha Vey on the day her sister went missing. I don't know anything about Jose. She didn't have that information. She was forced to tell that information. You also heard from Detective King. He's the canine who came and testified. And a lot of the evidence from the landfill, Ace pick-apart, that you all have seen is not related to this case. Has absolutely nothing to do with this case. The hits on that blue GMC Envoy at Ace pick-apart that the Detective King talked about, that's not related to this case. What did Gary Lindros tell you? He thought it was weird. Like, why are you all taking this vehicle? Why are you examining a vehicle that just got here a week ago? This vehicle wasn't even here on the dates that you all are questioning. Waste of time. His hits that he said, the picture that you saw of that dog laying down, that was a picture of a training material, getting ready for the day. Not a hit on something random, not a hit on a body. Detective King found nothing at the landfill that could be sufficiently connected to IS via DNA or anything along those lines. The evidence technician, Officer Lillard, they never located a body. They located some items, again, never connected to IS via DNA or anything along those lines. They talk about some underwear. Those underwear that have lips on them that Kimberly Mobley testified, those are IS's. You heard that testimony. Those underwear are a large. IS was a small. She was tiny. She was thin. Never even heard of someone upsizing underwear before. It's absolutely ludicrous. She wasn't pregnant at the time in February of 2018 when these underwear were purchased. You don't upsize underwear. That's not what happened. Those are not her underwear. And the testing done on it shows that there was no evidence, no DNA on that to connect that to IS. Similarly to those 2 bras that Mom says, oh yeah, those look like hers. There's no DNA to connect those to her either. None of those items found in the landfill that they pulled out could be connected to IS in any way. Terry Parker book. You heard from Ed Schmalfeld. I'm going to talk about him a little bit more later. I just want to mention it right now. He told you that items get dumped there from all over. But where did he tell you about the clothing? He told you Goodwill dumps in that same area. He told you that he saw clothing. Officer Lillard didn't want to admit that. Oh, the only clothing we saw were these. But what did Smallville tell you? No, there was clothing. Detective Bidlick. I'm going to go into some of this later, but Detective Bidlick is the one who wired Morris McClendon. He's the one who set things up, told Morris McClendon, we've had several cases together. You know what to do. You know what this is about. And then Detective Abbott. Detective Abbott, on this stand, admitted to you all that without the confessions and the conversations with his brother, there was no evidence, no physical evidence to connect Mr. Quiles to the murder of IS or unborn child or any sexual battery. It was through those confessions, statements to his brother, that led them down that path. And guess what? Once they heard that, there was no further investigation. There was no further looking into anything. They didn't question Mr. Quiles to find out what was going on. Mr. Quiles' brother told them about that confession. He told them. I don't believe him. He told that to police at the very beginning. That wasn't something he just came up with when he came and talked to you all yesterday. He's been saying that from the beginning. You also heard from Dr. Atchu. Dr. Atchu is the one who confirmed IS's pregnancy. And what did she tell you? She said she was looking down. IS was looking down. She couldn't really get a read on her. She made a note about wanting to speak to her next time she came into the office alone and to tell that to the front office at the beginning so Kimberly Mobley, her mom, would not come back. She noticed signs of abuse. And that wasn't just related to her being pregnant at 16. Rachel Thomas. Rachel Thomas told you. IS reported that she was a virgin, and her physical examination was consistent with that. She said, maybe there was something there, I wanted to get a better look at it, not sure. She never got a chance to look back because she did not get a follow-up appointment with her. But based on what she saw, she wrote in her report that what was reported by IS was consistent with her examination. Laura Draga, that was the evidence technician who did ballistics on the gun. No evidence that that gun was used in the commission of this crime. None. Only thing she could tell you was what? The gun works. It was preserved with preservative oils. She never stated that it was cleaned. She said that the oils that were left over looked like the type of oils that you use to preserve a gun. Regular usage. And then Nicholas Kutu. You heard from Nicholas Kutu. The majority of the evidence that you heard from him not related to this case in any way, except for those pill bottles. Those pill bottles came back with whose DNA? Kimberly Mobley's. Those pill bottles were found where? In SS's closet. 4 months after IS went missing. What did Naomi Mobley tell you? I've never seen those at my house. No other DNA is on that besides Kimberly Mobley's. Nothing to connect Mr. Quiles except for what besides what S has said. The credit union. Oh, let me go back. Those underwear from the rape kit with Kamar Humphrey. One want to be clear what he told you all. He could not tell us definitively if it was from 2 donors or 3 donors. He said he put both because he was not sure. If it was from 2 donors, there is no connection to Johnathan Quiles whatsoever. None, assuming 2 donors. The credit union custodian that came in. The card was used several times, and you saw that. Several times after IS is alleged to have been murdered. No longer able to use that account. There was a transfer, an internal transfer done on that account. The other internal transfer said what next to it? Nancy Ware, correct? That is what was put on there. Those transfers were done by Nancy Ware. This internal transfer does not have that information. Who was the other person who had access to that account? IS. There were some charges after that as well. Some games played. Those charges are on IS's own account, and Nancy Ware did not testify to using that account at all. I'll remind you of a few things that you heard from Johnathan and Gary Lindros. John Quiles was a great worker. Went above and beyond, would do what was necessary, saw something that needed to be fixed, he would do it. He's working diligently, never noticed anything out of the ordinary on those dates in question. You heard from about Google location. What were you told by several witnesses? He Googled Fastenal. Fastenal is a place to go buy parts. Detective Abbott told you that. Well, yeah, those places where you go to buy parts, same kind of parts that would be used at Ace Pick-A-Part. Johnathan and Gary might not remember asking Mr. Quiles to buy parts. That was a normal part of his job when they needed him to. And he went to Fastenal that day to buy parts. What else did they tell you about this area that was kind of restricted in that area at that time? They told you that where he was going, they did have cars that were for storage. They had a dirt and gravel pile that he would use for work purposes to fill in ruts and fix roads. And they were also fixing a fence back there. You heard Detective Abbott talk about that. There were several reasons to be in that area. After returning from buying parts for the business on company time, Mr. Quiles heads into that area. Completely normal. In fact, Gary Lindros said, it looks like he just parked right outside of the camera's view. They can't tell you whether he went into some secluded area or anything like that based off of that video. All you know is that he goes into that area for a few minutes. And that's supposed to be enough time to do what? Teams of people worked to process vehicles at Ace Pick-A-Part. You see Mr. Quiles picking up a vehicle on the 20th. What did Gary Lindros tell you all? Oh yeah, that's going to go get processed. Team of 2 people come and they do the first part. Take off this, empty the trash. Team of 2 people then go do this. Take it to the crusher, do this, remove the battery. All that process of production that he told you about. That wasn't a vehicle that just gets crushed and nobody takes a look at it. That vehicle was processed just like normal. And why was that the only vehicle that got moved that day? You've been told several times. It was raining. What did Gary Lindros tell you? He said, on that day, if people weren't able to work, they went home early. When did Mr. Quiles leave that day? Around 2:45 p.m. It was hard to work in the rain out there. There wasn't a whole lot that they could do. No problem. Go home today. Using that bucket versus the forklift. When first talking about that, he's like, it's a little strange. Then when asked, okay, well, doesn't he have to fill ruts in the roads? Doesn't he have to fix the road lands? Oh, yeah, okay, yeah, there's dirt and gravel over there. That makes sense. It's a totally normal function of his duties, things that he would do on a regular basis. I encourage you all to look at those videos. You'll see Mr. Quiles walking around, talking, doing his job, going in and out of the office, getting things for people, doing his job as he normally would. Look at him and see if you can tell his demeanor. If he looks like he's suspicious, as if there's something going on. I would submit to you when you look at that, looks like he's working. Talked to you about Ed Schmalfeld a few seconds ago. Clothing items. Clothing items from Goodwill are dumped at that landfill. What else did he tell you about that search? That 16-day search at the landfill? He told you they went through 5,500 tons of garbage. He told you the dimensions, and I can't remember them. He told you the dimensions, 20 feet deep, 3 to 4 acres wide, if I'm not mistaken. He told you he overestimated to make sure that that dumpster that they were concerned about was included in that search. I asked him, would that 5,500 tons of garbage, would that have met your overestimation to include that? He told you yes. Yes, he believes so. They searched. They did not find anything. Billy Brown. Important information from Billy Brown. They only dump at the Otis Road landfill. They don't dump anywhere else. When you're listening to that wire and you're wondering, is what he's telling, is what he's saying truthful? He's talking about Trail Ridge landfill. That's not even a landfill that American garbage dumps at. He claims that someone told him that from American Garbage. I would submit to you that he's making that up. The other witnesses you heard from. Damian Hatch. Damian Hatch claims that in 2022, February, let me be specific, he arrived in the same dorm as Mr. Quiles on February 11th, 2022. Started going to a Bible study that Brother D, Ulysses Dixon, runs. Started going to that Bible study on a daily basis. But you know who wasn't going to that Bible study? Mr. Quiles. You know what Damian Hatch told you all? They were going to that Bible study every day together. What did Ulysses Dixon tell you today? That's a lie. They're lying. Damian Hatch is lying. Mr. Quiles and Damian Hatch, Dino, as he's called, never attended Bible study together. Mr. Quiles didn't even go to that Bible study until the end of 2022, maybe the beginning of 2023. And how did Ulysses Dixon know that? He said he'd been trying to get him to come. Really good guy, doing trustee work, helping out people, but he wouldn't go to church. Ulysses didn't get anything for coming here and testifying. He even told you he's actually worried that's going to hurt him. But he came here to tell you all the truth. Tell you all that was a lie, what you heard from Damian Hatch. George Jackson. George Jackson told you all that he was not in control of the wire device. You heard at the beginning of that wire it jumps. It jumps a couple of times in the beginning. You don't know when it's being turned on. You don't know when it's being turned off. You don't know when it's being restarted again. Mr. Quiles, you heard this from George Jackson, was left alone with Morris McClendon. Morris McClendon, who is an expert at doing these things. He knows how to do what he needs done. He knows how to get information in the way that he needs to, by whatever means necessary. George Jackson wasn't in there when Mr. Quiles and Morris McClendon were having conversation. But what do you hear at the beginning of that wire? There's razors on the floor. Talk about a razor again. It wouldn't take much to threaten someone, to get them to say what you need them to say. Think about what you heard. Every answer is prompted. It's led. They're feeding information. They're telling him, signaling to him what needs to be said. What did Mr. Quiles' brother tell you? He makes up stories. He's known for it. He is known for coming up with elaborate, wild stories. Joseph Quiles told you, in the family it's a known thing. He did it when he was younger. He was caught supposedly high. Instead of telling his mom, oh, hey, just tried it out, he said, I'm a full-blown drug addict. He was sent to a drug rehab program for a year and kept up with that. He was never a drug addict. What did Joseph Quiles tell you? He said he was the only person in that drug rehab program who tested negative for drugs the entire time. He never had drugs in the system. But that's what he knows of his brother. He knows him to run on with these stories and go on even to his own detriment. He told you, if you ask him a question, he's going to give you an answer because he can't help himself. When he gets into character, he commits. He's going to perform for you. He's going to give you that story. He's going to keep it going. That's what Joseph Quiles told you. Carol Ann Clipp. Why do we call Carol Ann Clipp? You've already heard some evidence that activity was going on IS's accounts after the date the state alleges she was murdered. But not only that, she was seen. Carol Ann Clipp saw her the day after Christmas. She saw her walking. Carol Ann Clipp has nothing to gain by coming here. She didn't want to come here. But why? She told you why. She said she called because she believed in her heart and mind that that was IS. That was the right thing to do. Same reason she came and testified here today. Kamar Humphrey. I've already talked to you about him. But he lied. He admitted he lied about his whereabouts. Just about a month ago, not even a month ago, he denied even having sexual contact with IS. Why? You've already been charged and pled to a felony battery, so why would you lie? Why would you try to distance yourself from that? Because you got asked? You didn't want to be asked what happened? Again, nobody forced him to say the information that he said. What else is he lying about? Kamar Humphrey and IS communicated via Snapchat. He told you that. Now, of course, he wants to make it seem like they didn't communicate for that long. He's not dumb. He's not going to sit here and say, oh, yeah, I was in communication with her for months and months and months. Oh yeah, we had a sexual relationship for months on end. But guess what? IS told her best friend that that was the case. They had been communication for months. They were in a relationship for months. IS was in love with him. Jose. Who is Jose? Hispanic and black male, or mixed, 20 or 21, living in Azalea Ridge Apartments. Willie Sawyer told you all that Jose was in these apartments. The state talked to you about puzzle. They said each of these pieces, and they gave you a little graphic, each of these pieces is going to add up. When you look at all the evidence, you weigh the evidence back and forth. Are those puzzle pieces really all there? Or are there things missing? Are there puzzle pieces from another type of puzzle that don't fit? Are you forcing those puzzle pieces in? Or does it truly make sense? Because let me ask you, if IS is murdered at Ace Pick Park, December 20th or December 19th, there's zero evidence of a crime occurring at Ace Pick Park. No blood, no DNA, no cameras catching this happening. She's supposed to have supposedly been there overnight. According to Joseph Quiles and this supposed confession, he tried to strangle her and then left her there. Does that make sense? She just sat there waiting on him to come back? So much of the story doesn't make sense. Where is the physical evidence of this crime occurring at Ace Pick Apart? How could someone be shot in the chest, bleed, and there be no evidence whatsoever? He said to his brother he did it in the yard, or that comes out on a wire. The yard is where everybody works, not some secluded area off to the side. How could you do this in the middle of the day where everybody's working and no one noticed anything? There are people working in teams all over that place. You heard Gary Lindros tell you, there are people working in different stations, spread out around. You'll see the video, review those videos. You'll see people coming in and out all over the place. It's a busy place. I think he said that they see 300 plus people a day. On the weekends, it's more. That many people going in and out and all over the place, and no one notices anything? There's no physical evidence whatsoever? You heard on a wire that she was put in a bag. You heard Joseph Quiles tell you, oh, she was in a carpet. Can't have it both ways. We're just making up details now? So much of it does not add up. You'll see video of Mr. Quiles driving the forklift with a bucket without a bucket. You can see into the bucket. You can see on those camera angles. Look at that video. It doesn't make sense the way it's been told to you. Question that evidence. See if it does make sense to you. Let me talk to you a little bit about SS and her testimony. SS's testimony is rife with inconsistencies. She's changed dates. She's changed what's happened, how it happened, when it happened, how many times it's happened. She went from saying there was nothing at all that ever happened to describing in her own sexual abuse story of several occasions. But originally, what did she say? She said nothing happened at all. I don't know anything about Jose. She was asked these questions on December 19th and December 20th. She was asked several times by police, hey, tell us about that conversation that you had with your sister at the picnic table. Tell us what happened. She kept saying it was nothing. So many inconsistencies in her statements to you all. So many things that now she can't recall. I don't recall. I don't recall. I don't recall. You don't recall the things that you don't want to admit. SS is the only person who has said there was some code name for Johnathan Quiles. And what did she tell you about those code names? She actually added one. She said, oh yeah, he was also known as Eugene. SS's testimony is contradicted again and again and again by her own words. Why, if your sister is missing, would you not tell police everything you know? Everything you possibly know. Same thing goes for the family, because according to Naomi Mobley, December 6th, they were saying Jose was Johnathan Quiles. That didn't even come out to police until December 27th. Why would you wait 2 weeks after your sister is missing to say that type of information? She was protecting her? That's her excuse? That's her reasoning? She wasn't telling the truth. She had been told to say what she said. SS says she was told her sister was going to stay with her grandma, and that's why she didn't say anything. She knew immediately, she learned almost immediately that IS was not at her grandma's house. Her grandma, Nancy Ware, was informed. And yet, she still didn't think to say anything. But, oh yeah, by the way, I'm being sexually abused, and I've overheard my sister, and I know that Jose is Johnathan Quiles, but I'm not going to tell anybody that information, because that's protecting my sister. What other information did she withhold? She waited 4 months to talk to police about alleged sexual abuse. She waited 4.5 years to ever mention that she, on one occasion, was laying on a couch and overheard Johnathan Quiles and her sister having sex. 4.5 years. That never came up. She actually never even reported that to police. That was something that was said in a deposition. When they couldn't find IS, sister group is circling those allegations and accusations. They turned to SS. You're malleable. Go along with this narrative. This fits it. Now, all of a sudden, this family is, oh yeah, we knew. Oh yeah, we saw the signs. But nobody reported anything for weeks? I saw this terribly inappropriate hug. I didn't like the way he looked at her. But you all did nothing? The hard part with SS is so much to keep track of, so many things to keep straight, so many stories to try and line up. It's hard to keep track of all of that. Inevitably, you get caught up. Let's talk about those pills that were found 4 months later as well. 4 months after IS goes missing, Don Quay and parsley pills are found inside Kimberly Mobley's house, inside SS's closet. Naomi Mobley testified that her Amazon account was used. But what else did she tell you? She said, I had Amazon on my phone and on my laptop. This was in October of 2017. Mr. Quiles' femur was broken. He was recovering. IS and SS and their siblings would come over to the house. They'd help out. They had access to their Aunt Naomi's laptop. She said that they would use it often, play games. She claims no one had her password to her Amazon account. The Amazon account is up on your computer, and it's not signed out. You can have access to it. And we know that they used her laptop. Her credit card is saved to her Amazon account. All you need is for that Amazon account to have not been signed out, and anyone could purchase whatever they wanted on that. And don't forget whose DNA was found on those pills. Think of all the physical evidence that's been listed out to you. It's not connected to Mr. Quiles. There's no DNA that comes back to him. There's no DNA that comes back to IS. Let me talk to you about the red van. The red van was a family car. No one's denying that Mr. Quiles drove that car or anything along those lines. But what did Naomi Mobley tell you? She said, I told him to get rid of these cars. Our house is looking like a parking lot. So what car is he going to get rid of? A broken down vehicle? His Durango that he's put a ton of money into and what Naomi Mobley described as his baby car? Or the vehicle that she said, don't sell my car. There's only one vehicle left to sell. Nothing nefarious about that. This is the logical vehicle to sell when they needed some money. The video surveillance. The video surveillance from the dates that IS is alleged to have been murdered are so critical. The area that the state alleges Mr. Quiles took IS is right in an area near a fence that's opened. A fence that's opened and you can see from the office. Gary Lindros told you, oh yeah, you can see right into that area from the office windows where I sit. Not only are there people working there, not only are there people fixing a fence, but it can even be seen. That area can be seen from the office. And this horrific murder is supposed to have happened right under their nose? A person's transported in there and kept there overnight and nobody notices? What did he tell you? He said, that's not even likely. Highly, highly unlikely for that to have happened. Not that anything isn't possible, but I'm just asking you what's probable. Police didn't investigate this fully. They set their sights on Mr. Quiles. He was their target. All the tips and leads and other possible routes they could have gone, they left hanging. They failed to properly investigate. They failed to follow up and check to make sure. The state gave you a list of things that they believe prove premeditated murder. But I would submit to you that those very same things are contradicted left and right. Mr. Quiles' own words contradict himself, especially for somebody who makes up stories and elaborate and goes on with it, especially if he's been threatened to provide information about something he didn't do on a wire so that Morris McClendon can make a case. They claim that cameras, his activity at work, is going to prove something. I submit to you it doesn't prove anything. The fact that he left work, he had a legitimate reason for leaving work. And if he's on company time, it's no surprise he didn't clock out. I asked him if he went to go buy parts, would he have clocked out? He said no, he'd still be on the clock. Now, as you all are weighing the evidence, questioning it, we ask that you would hold the state to their burden. That burden that we've talked about so many times over the last couple of weeks. Each and every element of the crimes charged must be proven beyond and to the exclusion of every reasonable doubt. I've gone through with you tons of reasonable doubt. Tons of questions, things that don't add up, things that don't make sense, that leave you plenty of reasonable doubt that Mr. Quiles committed the crimes that he's been charged with. Talked about that puzzle. How many of those pieces have reasonable doubts to them? Because each piece of that puzzle that they showed you should be proven beyond and to the exclusion of every reasonable doubt. All the elements, all of the pieces, they have to fit together. And I would submit to you that when you look through, you weigh the evidence, you're going to find those doubts. As you come back to that, if you're left with that question, if you're not certain, if you don't have that abiding conviction of guilt, that is reasonable doubt. You all have options here. You have options for the first and second counts. There are lesser includeds. So if you believe, even after looking at all of the reasonable doubt that's been presented to you over the last 6 days of testimony, Mr. Quiles committed this murder, look to his words then. He talked about it being a spur-of-the-moment thing on the wire, not something planned out. That's the difference between first-degree murder and second degree, that premeditated portion. There are lesser included options for you all if you get there. But I would submit to each of you that when you weigh the evidence, when you go through, when you question what has been presented to you, and you determine what's reliable and what is not, I submit to you that you will find Johnathan Quiles not guilty. Thank you.
Members of the jury, feel free to stand and stretch if you would like before the state gives their rebuttal. I'll do it with you. That makes you feel better.
Here's the little thing. Actually, exit out of it, don't I? Got it, right?
State whenever you're ready.
Thank you, Your Honor. May it please the court,
Yes, sir, of course.
counsel, ladies and gentlemen. Facts are stubborn things. And whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of facts and evidence. In 1770, the second president of the United States, who was a lawyer at the time, said those words, John Adams. He stood in a courthouse not like this one, not with air conditioning, not with our comfortable seats, and stood up for hours in front of a jury of people. And he said that. One of our greatest founding fathers, who helped wrestle with and create our founding documents, as this court so eloquently said, right after we picked a jury, to this day, we're still adhering to that great document called the Constitution, written in 1787. Facts are stubborn things. Here's a fact. The defendant confessed 3 times to killing Iyana. That's a fact. And what's even a more important fact to note is the similarities between those statements of gentlemen that do not know each other. Joseph, who lives in New York, gave consistent facts about what happened. They go point out one. Oh, she's wrapped in carpet versus she's put in bags. All say she shot. All say she shot at Ace. All say he summoned her there somehow. All say she's pregnant. All say he wanted that baby dead. The consistency of those 3 consistent confessions should make me sit down right now and give you this case. And stop insulting your intelligence. Because those 3 facts, to match like they did, of 3 gentlemen that do not know each other, have never discussed anything before. One's in jail. These other 2 guys, Maurice and George Jackson, on a wire. And some man in New York who's the defendant's brother never confers. Ever. Those 3 confessions mesh. That's a fact. And it's stubborn. And it's hard to argue around, but you just heard it. Counsel gets up here and says, well, there's holes in the state's case. holes came from this man right here. Those hands right there, he scooped up dirt or covered up dirt, wrapped her up. Whether it's a carpet or whether it's 2 bags, doesn't matter. We don't have to prove that. He told all 3 of them, he put her in a dumpster at work. And they just happened to get that right? That just happenstance? Don't let the defendant get away with holes that he created. He tried to get rid of the body. He tried to get rid of the blood. He tried to go shoot his gun. Make it look like he shot her recently. You know, he couldn't kill her anywhere else. You know why? Because his wife and him share their location. If he goes running off way out on the west side or out to Bayard or out to wherever and dumps her somewhere, she said, we share our data. And guess when his is off? Guess when his cell phone is off? Guess when he leaves work? Guess when this happens? Guess when he lures her from Terry Parker? It lines up with the cell phone data. It lines up with her data. She has no communication whatsoever. She leaves Terry Parker at 11:05 a.m. Guess when he leaves his work? 11:15. They could come up here and argue, well, he ran an errand at work. That's a 25-minute ride. Where are the other extra 53 minutes? That's why we had Detective Abbott testify to that, to show he most certainly had time to go meet with her. But the defendant, he made a grave mistake. Even though he tried to clean up, even though he tried to get rid of evidence, even though he tried to get rid of the body, even though the Don Quay is on his wife's account. By the way, it doesn't, listen, if the girls got on the mother's account, which they did not, there's no evidence of that. Okay? If those girls got onto that account, where did they get that idea? The Snapchat alone tells you there's a lot of sex going on between the defendant and IS under everybody's nose. But he's the one sneaking around doing that with IS. It's a horrible secret to put on a 14 and 15-year-old child. It's despicable. Despite that, despite all the Snapchat messages that he chooses to communicate with them on, that automatically deletes. But he doesn't talk to his wife that way. He talks to the nieces that way, both IS and SS. And oh yeah, now he's taking a run at another niece, ID. Guess how he spoke to her? Snapchat. He knows how to delete evidence. But he made a grave mistake. He ran his mouth. And he told his brother. Facts are stubborn things. And that brother sat here yesterday, and he, the defendant, put him in a horrible position. Just like he did with SS and IS. But you can say all day long, as counsel just tried, well, he didn't really believe him. We picked that phone up and called the police. He said, and I'm sure you heard it from that witness stand, when when I'm around him, he's confident. He's himself. And on this call, he's panicking. He's frantic. Why? Well, then out comes what he tells them. I got this girl. She's pregnant. She's my niece. I don't know what to do. I tried to strangle her. I can't stomach it. She's back in the car. By the way, they asked, the defense says, that doesn't make any sense. It doesn't? Newsflash, folks. When you strangle somebody, they can pass out. You strangle a little girl, sign to that man, he can pass out in a car. And he calls his brother back on the same day. I took care of it. Listen, those are chilling words. He calls his blood brother and says, I took care of it. After just telling him, she cannot have this baby. That alone convicts him. That fact is so stubborn. So stubborn. When you add that the second confession, the wire comes along and matches it almost perfectly. Almost perfectly. You're having sex with your niece? Remember that one? Well, yeah, what about your wife? Well, yeah, she's pregnant and the doctors say she's high risk, so we can't have sex anymore. We even know why he's having sex with SS and IS. We know why. He got her pregnant. It's all over the wire. Your ears got to... Listen, we apologize for the language and the things that you had to hear. Your ears heard some chilling words about right out of his mouth describing how he killed that little girl. And talk of the facts, almost like everything that you see here, they talked about. Landfill. She's pregnant. Listen, DNA in the underwear. Facts are stubborn things. We don't even have to prove motive, ladies and gentlemen, but we sure did. He could not let that baby be born. And he was determined to make sure that Hazel did it. As he said on the wire, I think it's a girl or something. That little girl's a human being. She had a name. And he killed her. Now, we're talking about puzzles a lot. My boys were little. We bought an alphabet train. The alphabet train was something it came really two ways. You have it in a puzzle, but they also had little cars that connected together. And little wheels on them. But they were these little shapes, they were like about that big. And they were in the shape of the letter. And you would connect them to learn your alphabet. You'd line it up on the floor. My boys did. That's how you taught them the alphabet. And each one of these had shapes on them. They had the shape of themselves, whether it was an A or a B or an H. What we just did for you is lay out all those alphabet pieces. We're asking you to put them together. What Miss Michelle just did is she took an individual letter and said, well, I'm going to take this I out, and I'm going to hold it up and say, well, couldn't it be a 1? Or I'm going to take the W out, and I'm going to turn it over, flip it over, show it to you, go, well, it could also be an M. Isn't that possible? How many times did you hear that question from counsel on cross-examination of all the state witnesses? Well, isn't it possible that? Isn't it possible this? Isn't it possible that? Isn't it possible? Isn't it possible? Isn't it possible? Do you know what reasonable doubt is? It is not a possible or speculative doubt. Then why ask those questions? The counsel comes up and says, well, there's no DNA that connects the defendant to this. Did she just say that to you? Are you kidding?
his DNA doing on the inside of these underwear? I don't care if that's spit, saliva, semen, touch DNA. It has no business being on the most intimate, private areas of a 15-year-old little girl's underwear in March of 2018. This alone tells you what's going on. We spent, I don't know how much time asking whether this particular DNA was, well, do you know whether it's sperm? And he said, the expert said, well, it's a sperm cell fraction. I don't care what it is. What he was certain about was that it was the defendant's DNA on the interior. You hear what he said? A yellowish stain? Now, come on. It wasn't enough to tell us whether it was a sperm cell or a blood cell or a saliva cell. That does not matter. That's trying to create possible doubt. And that is not reasonable doubt. And Nicholas Kotu, he explained it. He says, listen, he goes, it's just not enough to call one way or the other. And he spent all this time on it. And he says, listen, it was a sperm cell fraction. That's what he said. But setting all that aside, what the defense just did with that DNA is they held it up and go, well, it's not really a Z in the alphabet. If you pick it up, pull it out, turn it on its side, it's now an N. And that's not what your job is. Your job is to take all of this evidence, put it together, and render a true and just verdict. Ladies and gentlemen, that evidence right there is the most inculpatory piece of evidence that exists on the face of the earth. And it existed in a place, the last place a 33-year-old man's DNA should be, is in a 15-year-old girl's underwear. And then they bring up, well, this Snapchat. Counsel says, well, it's only half the the way the records came in. We got half the conversation. Listen, you can read it 100 times, and there's no other conclusion. We were asked, and we made it clear, please use your common sense. You can't read those Snapchat messages and draw any other conclusion rather than it was between this defendant right there. No other way to read it. He names her. He uses the sister's nickname. He uses your aunt. He uses one time about the whole kiss goodnight. Oh, well, a kiss you goodnight. I'm in your house. It's clear. If that's not who this is, then this defendant and IS have an exact similar scenario going on at some other house somewhere else, and there's some other girl named Maya, Iyana. Folks, that makes no sense. None. And then counsel makes a big deal about, well, Naomi asked him, hey, what are you doing? I'm on Snapchat. And she says, well, it's no secret. Well, you know what she didn't do? She didn't go over there and say, listen, husband, let me look at your phone and make sure that's what you're doing. She didn't do that. Ever. Then they argue, well, there's no body, there's no blood, and all the... Listen, we established she does not exist on the face of the earth, and we know it took a long time. And we greatly, greatly appreciate your patience. You all been, as the court said repeatedly, your attention has been unbelievable. Your promptness, your attentiveness. But let me make this perfectly clear. We had to do that. In homicide cases, usually body laying there. Okay? This is a homicide case. We had to establish the body doesn't exist. And we did that. Not one shred of existence. Counsel can get up here all she wants. Says, well, there's more charges on that account. Go look at them. Did you remember what they said in the opening statement? Well, she went to Wendy's that day. She went to Wendy's that day. Mr. Davis sat right here and said to you an opening statement. Remember what lawyers say. That's not evidence. When I had the custodian on the stand, tell me about that Wendy's trip. Oh, no, that wasn't December 19th. Look in the body of the transaction. It's December 13th. It was posted on the 19th. Why are they up here saying that to you? Reasonable doubt is not a forced doubt. Then why say it? They got the same records we do. Why come in here and ask questions about this Wendy's? Oh, no, that wasn't on the 19th. She made that perfectly clear. Then they make, well, there's no blood. We talked about that. He got rid of that. There's no murder weapon. Yes, there is. Yes, there most certainly is. Why? Number one, because he said so not once, not twice, but 3 times he said so. He's my gun. He even talks about it extensively on the wire. Yeah, the police hadn't even gone and got it yet. They start laughing about it. Are you kidding? This girl is thrown to trash, and he's laughing about the police hadn't even gone and got the gun yet. Counsel in the opening statement, they just argued it again. Oh, the state's assuming this happened at Ace. The state's trying to make this into their crime scene. The state's not doing any such of a thing. The state pressed play on a wire, and that's what he said. That's what their client said. He said it to Joseph. He said it to Damian Hatch. Are you kidding? Is the state just sitting over here, we're just dreaming stuff up? He said it. And they have, the state's assuming Ace is the scene. Really? I killed her at work over off in a remote area over there. Put her in bags. Put her in the trash. But they take this video and they say, if we're taking the B out of the alphabet, we're holding it up going from afar, it kind of looks like an 8. Right? That's what they're doing. That's what she did in her whole closing argument to you. Pulling pieces of evidence out and isolating and holding them up to you and say, well, this isn't really a number 1. It's not really a letter I, it's a number 1. Are you kidding? Three different times, I killed her at work. And they're telling you, they're assuming where he killed her was an Ace. Use your common sense. Now they bring up this red minivan, and they say, well, there's no evidence in it. The state, what else is he supposed to sell? All his wife asked Naomi Mobley said at the time, I said, we got too many cars in the driveway. You pick which one. And he sells the one that you see he goes to work in every day. He sells that one. And I got news. You can sell a broken down car. What do you think Ace pick-apart is? What do you think car lots are? What do you think junkyards are? You can sell that other Dodge. He picks the one that was reused in getting that girl Ace picked apart. And shortly, she told him that like mid-December. It was sold in like 8-9 days. Got rid of that pretty quick. And then counsel argues about that. Well, what else? What else can he sell for money? Broken down cars you can get. That wasn't even the issue. You heard Naomi under oath say, "No, I just wanted too many cars out there. Our driveway was looking like a junkyard." Then she really took a lot of time picking on IS in her testimony. Ladies and gentlemen, let me make this perfectly clear here. For the defendant to put a 14-year-old girl in the situation he put her in is despicable. the weight that was on that little girl's shoulder. She knew what was going on. She's not going to tell. Then she says, oh, Naomi pulled them both aside and said, is anything going on? The defense wants you to believe that both these little girls go, yeah, we're having sex with your husband. Are you kidding me? Is that realistic? Or again, are you trying to force doubt on you and create this forced doubt? You bet those little girls carried around a horrible secret. It put them in a situation that no 14-year-old knows how to handle. And she says, well, once she figured out that she didn't make it to her grandma's, why didn't you tell SS? Folks, again, the answer is very simple. She's carrying around a secret that's like, oh my God, if I tell, I'm going to lose my sister's friendship. She's got to be run off with him. Maybe he's got her in a hotel. Who knows? There's so many ways for a 14-year-old to interpret that. Oh my gosh, I mean, imagine that SS's position that she was in. SS is saying to herself, if I tell, I'm going to forever lose my relationship with my sister. And she's missing, oh, please come home, please come home, please come home, please come home. It's a horrible position that he created. He did this. Now they want to come in and go, oh, SS should have disclosed this quicker. Easy for them to say. Then we hear, I think they took a shot at Dr. Atchie. They said, well, she's looking down at the floor. She looked concerned. I think there was testimony she wasn't talking. If she wouldn't make eye contact, Dr. Atchie's the one that confirmed the pregnancy. Listen to this. You know what Dr. Atchie said? 22 weeks, 5 days pregnant. That's huge. Why? 22 weeks and 5 days backwards of December 13th, which is the date of the appointment, was July 7, 2018. You know what July 7, 2018? There was a family get-together. When they came back from, do you remember, way last week? The two little girls went to spend time with Grandma Nancy Ware up in Columbus, Georgia. Come back. SS goes home. IS on that night, for 2 nights, went to spend the night with him. Wow. That's why the family blew up in early December 18. They figured it out. Then they up here criticize. Miss Michelle says, well, these aunt, grandmother, I don't like the way he hugged her. I don't like the way he looked at her. Oh, they didn't do anything? Well, first of all, it's not a crime, to give somebody an inappropriate hug. And it's also, I don't like the way he looks at her. That was an aunt and a grandmother. Remember those? And both said, counsel just argued to you, by the way. They didn't do anything about it. Yes, they did. The grandmother went to Pam and said, don't let him around the nieces anymore. You remember that? Those are little details that over the week and a half that you've been here, you may forget. Remember, they did do something. And number 2, don't ever question a grandmother's intuition. I learned that a long time ago. The grandmother walks out to a backyard at a family function, and it's just the two of them, the defendant and IS, and he's startled, he pulls away, and it made that grandmother concerned enough to go tell Pam. Not about the hug, but hey, listen, you probably want to keep him away from the girls. You need to give permission if he comes over, and you need to be watching out. They did do something about it. They just tried arguing to you that they didn't, and they did. Forcing doubt. Don't forget the timesheet. This timesheet up here with the defendant, listen, he leaves for an hour and 13 whatever minutes. He doesn't clock out. And you can say, well, it's the parks run to the store, whatever. What about those 53 minutes? Another. He knew what he was going to do. Told his brother he'd been planning it for months. He knew what he was going to do. He blended in at work. Violated company policy, as I asked both the Lindroses. If he leaves for a long period of time on a personal issue and leaves and doesn't clock out, is that allowed? That is not allowed. I think they made a couple more arguments about, well, you can't ever see IS on the cameras at A's. Of course not. Of course not. What is the expectation that, listen, well, he's going to put her on his arm, just going to walk him through his work with this 15-year-old girl? Are you kidding? 16-year-old girl by that time? Of course not. You bet she's not on the cameras. But what does he say on the wire? Them cameras are crappy. You heard it. George Jackson. Yeah, it's crappy camera systems. I know where the cameras don't show. They really argued to you also about the landfill and clothing. I was just touching on this briefly. But listen, when the detective, who's got, 30 years of experience, Detective Shannon Lillard, she's worked major crimes, homicide, crime scene unit detective. When she says, look, I was out there every day. I know what I saw. They want to throw, well, Goodwill dumps there. Got to be other clothes, right? No. Yeah, so what? Ed Schmalfeld said that there's Goodwills there. That doesn't necessarily mean that the area that they were checking had clothes. And by the way, these clothes, isn't it odd? Forget the fact that it's Victoria's Secret that Mom says, yeah, that's hers. Forget that. It's found in the same isolated area. It's a big area, don't get me wrong, but the same area that the engineer, Ed Schmalfeld, says, this is where you need to search if that's when that truck came here. 20 feet down, these 2-3 acres. What's in that 20 feet down, 23 acres? More Victoria's Secret underwear. By the way, it's not in bad shape. Okay, people don't just throw that. It's expensive. People don't just throw that out. Isn't it odd that it's there near a Terry Parker book? Oh, don't forget this. This is the trashiest of trash. Ace pick-apart paperwork in the same area. What in the world is Ace paperwork doing near a Terry Parker book, near clothing that's Victoria's Secret items? What is that stuff doing there? And they keep saying, no evidence, no evidence, no evidence. This is evidence, this is evidence, this is evidence. Yes, Ace pick-apart dumpster was dumped there because you see stuff like that. We also know this little girl packed a whole bunch of Victoria's Secret stuff. We know that's missing from a room. We know that. That's there. Does it have to be the same size? So she grabbed a pair of her mom's or her sister's or whatever. Doesn't matter the size. It doesn't matter the size. There's a Terry Parker book there. What's that Terry Parker? Of the 50 or 60 schools in Duval County, the Terry Parker book is there. Folks, all this evidence screams at you. It screams who did this. The circumstances show who did this. The evidence, the phone, the Snapchats, and I haven't even mentioned wire in this statement, or the statement to his brother. The circumstances alone show who's in trouble. He got his little niece pregnant. The motive is there. Then they call Kamar Humphrey, right? They call Kamar. Well, we didn't get along in the depot. That was clear, right? And then he says, I lied to you. Then I come up and I'm like, wait, you lied to her. You weren't getting along with her. But I'll tell you what, didn't you get on the news? They didn't bring it up. The defense didn't bring it up. We did on cross. Didn't you get on the news pleading for the public to come forward with information about this girl? Yeah, yes, sir, I did. And they call him. Now that wire, we're not going to look through all this. Let me just make this very clear about the wire. There is only one conclusion to draw from listening to it in its entirety. We apologize, 2 hours, but you had to hear it. It is littered littered. It is filled with incriminating statements that lead to one conclusion. Here's a couple examples. Man, if the body's dumped with book bag and stuff, then it's easier to find. The defendant, no, it was all separate. This is straight from the defendant. When my wife got pregnant, she's so high risk, they cut us off from sex. Why not get rid of your gun? That's in there. You heard it yesterday. Well, it's registered to me, but that's all taken care of. I took it and shot it at the gun range to blow off steam. Didn't need to blow off steam that much because, as his wife said, he slept like a baby after she disappeared. Whole family's in a tizzy, and he's curled up sleeping like a baby. That's offensive. So he went and blew off steam. Why? Thought he got away with it. Boy, that pressure was coming down. You see it in those Snapchat texts. Oh, you see it. A man talking to a little girl like that. Manipulative. Then on the wire, man, you cleaned it all up. Then that's when he said, yeah, I even went to the range that day. Man, did you kill her one day and dump her the next? Yeah. Man, did you made her sit in a car when she got shot? No, she wasn't in no car. How long she been dead? Well, the heat index, he went into his little Discovery Channel explanation. You remember that? He said, she's been cooking out there. She's been cooking. That little girl is laying up dead in that dump somewhere. That's the words that come out of his mouth. She's been cooking out there. Man, where'd y'all have sex at? You sneak around? Well, yeah, random spots. Like we went riding up to the store or in a car. And counsel stood here and tried to argue they let him. Did she just really say that to you? You sat here and listened to 2 hours patiently, a long audio, and not once is there a threat. She said, the razor's on the floor. Are you kidding? They're laughing it up. 98% of the time of that audio, they're just sitting back talking, casual, hanging out. Man, how'd you get rid of the body? There's laughing going on. And they come up and argue to you, again, trying to force this doubt. Folks, that's you know what to do with that. So I come to a close, talk a little bit about that Don Quay and the parsley. Listen, it's not just like the confession. You can say, well, listen, I'm going to be frank with you. One confession alone convicts him with these circumstances. One of those alone is enough to prove beyond any doubt who did this. For your ears to hear a confession and get a confession from a blood brother is just that much more compelling. But think about these pills. It's not just the fact that these pills existed. They were ordered on the defendant's wife's account, and she came in here and swore under oath, and let me tell you, convincingly so. I didn't order them. Did you notice the count on these? These are 100 counts. Both of them. When the detective collects them, they put every one in here. There's nowhere near 100 in these. And they're sitting at the top of the closet of the victim, IS. And they tie back to one account, the defendant and his wife's.
By the way, she's pregnant at the time. You catch that? She doesn't need these. Who are they for? It's clear who they were for. Then they come up and ask you, well, you remember Barbara Johnson? She's with Gun Gallery. You don't know whose signature's on this form. Well, it says Johnathan J. Quiles. There's his signature. Yeah, but you don't know he signed it. Forcing doubt on you. Trying to create possible doubt. So I call Naomi quote, Miss French and I call Naomi Mobley to the stand. We walk it up and show it to her. Is that your husband's signature? That's his signature. Why are they asking these kind of questions to you? And by the way, the whole thing about Ace and like, how does he know this property so well? How's he going to do this to all these people around? He knows it better than everyone. Why? Don't forget that map. The Lindroses say he brought us this map unsolicited. He'd only been an employee here he'd only been an employee there for about 90 days. So somewhere in the middle there, they said he brought this map, showed all the weaknesses in the fence. He's been all over the back of that property. Joseph Quiles, he took the stand and he testified, these are the things my brother told me. I said, sir, do you want to be here? No. You love your brother? Yes. I'm going to describe the brother like this. There's a quote from John Wayne's biographer. Guy named Scott Eyman, E-Y-M-A-N. And he wrote that John Wayne is this kind of a man. Quote, he had a spirit that makes firemen rush into a burning building because it's the right thing to do. End quote. Joseph Quiles did the right thing. It was the right thing to do. Joseph Quiles broke one of the strongest bonds that exists on earth. And that's a brotherhood bond. He came into a court of law and he raised his right hand and he said, this is what he told me. I couldn't stomach it, so I shot her. I had to get rid of that baby. Counsel stood right there and tried to get him to say, well, you don't believe that. You don't believe that. You bet he doesn't want to believe that. Bet he sure as heck picked up that telephone on January 8th of 2019, called the police. On January 8th, 2019, remember this, and calls the police. On January 10th, on January 10th, 2 days later, you heard the words right out of his mouth on the wire, matching what Joseph Quiles testified to. Taking the witness stand and doing the right thing. And I asked him why. I said, Mr. Quiles, I said, you tell this jury why you're doing it. He said, it's the right thing to do. We don't tolerate the use of women in our family. I wanted the police to have this information so they can go look for her and maybe bring this family peace. Joseph Quiles' testimony alone convicts him. With all these circumstances surrounding and all the evidence that surrounds that confession, that alone convicts him. Lastly, the defense just argued to you that we don't have any evidence, right? They said there's all these holes in it. Look at your video board and look at the evidence that you've heard in this trial. I'm not going to read every one of those to you. There is a mound
of evidence here. There is evidence overflowing here. There is evidence that will bring us to phase 2 of this trial. There is evidence that the defendant is guilty of first-degree murder of Iyana Sawyer. There is evidence that he is guilty of killing her unborn child. Proved beyond a reasonable doubt. And there is evidence we have proven beyond a reasonable doubt that sexual battery occurred on IS by the defendant. That presumption of innocence that you have done nothing but adhere to and pay attention so attentively, you can now just strip that off of them. This case is now where it belongs, and that's with the people. We talked about those 3 branches of government when we started this, the judiciary, the executive, and the legislative, but it's the people that make decisions. It's the people, you as a jury, that brings justice, which is so needed in this case. We now ask you to go back and convict him of all 3 counts, guilty as charged as to all 3, and carry us to phase 2 in this trial. On behalf of Ms. French and myself, we thank you for the last week and 4 days. Thank you, Your Honor. Nothing further.
Members of the jury, I'm going to give you a break before I read you the jury instructions and charge you in this case. It's 3:49. Come back at 4:15. I'll read you the jury instructions again, and we'll go over timing, scheduling wise, about what you guys want to do tonight, however long you want to stay, your verdict takes, and we'll certainly abide by those wishes. So I'll see you guys back at 4:15. A nice break. Or the jury's outside our presence. I still have counsel for the state defense. Mr. Quiles present. Anything we need to handle during the break from counsel? No, Your Honor. All right. You guys can have a seat, of course. I'll see you guys back at 4:15. I'll charge them. And like we talked about, I'll tell them they will be here as long as they want tonight. I'll let them know that we're more than happy to order you dinner if you want. We're more than happy to break at whatever time you want and come back tomorrow. So it's really going to be their call. They said they can stay later tonight. We'll see what they decide to do at that point. But I'm going to charge them and send them back and see what they decide to do and maximize our time together. So appreciate you guys, and we'll see you back at 4:15. guys may have a seat. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. You will get a hard copy of these instructions. Feel free to take notes if you want. Feel free not to take notes, but you will get a hard copy, just so you guys know. Johnathan Quiles, the defendant in this case, has been accused of the crimes of 2 counts of murder in the first degree and 1 count of sexual battery. Johnathan Quiles is accused of first-degree murder in counts 1 and 2. First-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find IS as to count 1 and or the unborn child of IS as to count 2 was killed by Johnathan Quiles, you will then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder or second-degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any of the following circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with the usual ordinary caution and without any lawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden insufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Johnathan Quiles will be found guilty of first-degree murder or any lesser included crime. As to count 1, to prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, IS is dead. 2, the death was caused by the criminal act of Johnathan Quiles. 3, there was a premeditated killing of IS. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If you find that Johnathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he discharged a firearm and in doing so caused great bodily harm to or the death of IS, you should find the defendant guilty of first-degree murder with discharge of a firearm causing great bodily harm or death. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and does not include mere bruises. If you find that Johnathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of first-degree murder with discharge of a firearm. If you find that Johnathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of first-degree murder with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to, or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. To actually possess a firearm means that the defendant, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access, with the intent to use the firearm during the commission of the crime. As to count 2, to prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, the unborn child of IS is dead. 2, the death was caused by the criminal act of Johnathan Quiles. 3, there was a premeditated killing of the unborn child of IS. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation was previously defined for you. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If you find that Johnathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, and in doing so caused great bodily harm to or the death of the unborn child of IS, you should find the defendant guilty of first-degree murder, discharge of a firearm causing great bodily harm or death. Great bodily harm has previously been defined for you. If you find that Johnathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find him guilty of first-degree murder with discharge of a firearm. If you find that Johnathan Quiles guilty of first-degree murder, if you find that Johnathan Quiles committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of first-degree murder with actual possession of a firearm. Firearm has previously been defined for you. To actually possess a firearm has previously been defined for you. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proven beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are as follows: second-degree murder, manslaughter. The instructions for second-degree murder and manslaughter as lesser included crimes for first-degree murder are combined into one instruction for simplicity purposes. The only difference is the name of the victim in the elements of the crimes. As to count 2, to prove the lesser included crime of As to counts 1 and 2, to prove the lesser included crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. As to count 1, IS is dead. As to count 2, the unborn child of IS is dead. Element 2, the death was caused by the criminal act of Johnathan Quiles. Element 3, as to count 1, there was an unlawful killing of IS by an act imminently dangerous to another in demonstrating a depraved mind without regard for human life. As to count 2, there was an unlawful killing of the unborn child of IS by an act imminently dangerous to another in demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another in demonstrating a depraved mind if it is an act or series of acts that 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had the intent to cause death. If you find that Johnathan Quiles committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, and in doing so caused great bodily harm to or the death of IS as to count 1, and or the unborn child of IS as to count 2, you should find the defendant guilty of second-degree murder with discharge of a firearm causing great bodily harm or death. Great bodily harm has previously been defined for you. If you find that Johnathan Quiles committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of second-degree murder with discharge of a firearm. If you find that Johnathan Quiles committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of second-degree murder with actual possession of a firearm. Firearm has previously been defined for you. To actually possess a firearm has previously been defined for you. As to counts 1 and 2, to prove the lesser included crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Element 1, as to count 1, IS is dead. As to count 2, the unborn child of IS is dead. Element 2, as to count 1, Johnathan Quiles intentionally committed an act or acts that caused the death of IS. As to count 2, Johnathan Quiles intentionally committed an act or acts that caused the death of the unborn child of IS. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as been previously defined to you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death. Only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Johnathan Quiles committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of manslaughter with a firearm. Firearm has previously been defined for you. If you find that Johnathan Quiles committed manslaughter, or you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of manslaughter. As to count 3, to prove the crime of engaging in an act that constitutes sexual battery upon or with a child 12 years of age or older, but younger than 18 years of age by a person in a familial or custodial authority, the state must prove the following 3 elements beyond a reasonable doubt. 1, Johnathan Quiles engaged in any act that constitutes sexual battery. 2, at the time, IS was 12 years of age or older, but younger than 18 years of age. 3, at the time, Johnathan Quiles was in a position of familial or custodial authority to IS. Sexual battery means the sexual organ of Johnathan Quiles penetrated or had union with the female genitals of IS. Ignorance of IS's age, IS's misrepresentation of her age, or the defendant's bona fide belief of IS's age is not a defense to the crime charged. Bona fide means genuine. It is not a defense that IS was willing or consented to engage in an act that constitutes sexual battery. IS's lack of chastity is not a defense to the crime charged. An object includes a finger. Union means contact. Female genitals includes the labia minora, labia majora, clitoris, vulva, hymen, and vagina. As to counts 1 and 2, the state must prove the crimes were committed on or between December 19 and December 20, 2018. As to count 3, the state must prove that the crime was committed on or between December 1, 2017 and December 20, 2018. It must be proved only to a reasonable certainty that the alleged crimes were committed in Duval County. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. During the course of this trial, you heard testimony from SS and ID. The testimony from SS regarding other crimes, wrongs, or acts allegedly committed by the defendant shall be considered by you only as that evidence relates to motive, opportunity, intent, plan, absence of mistake or accident, or corroboration of IS as it relates to count 3. The testimony shall not be considered as to motive as to counts 1 and 2. The testimony from ID regarding other crimes, wrongs, or acts allegedly committed by the defendant shall be considered by you only as that evidence relates to motive, opportunity, intent, plan, or absence of mistake or accident. The testimony shall be considered as to motive as to counts 1 and 2. However, the defendant cannot be convicted for a crime, wrong, or act that is not included in the indictment. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in this case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony or misdemeanor involving dishonesty or a false statement? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusation against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand or to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether when the defendant made the statement he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not, in accord with the law. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. So there's 3 verdict forms. One for count 1, one for count 2, one for count 3. I'm holding them in my hand. I'm going to go over the one for count 1 for you so you understand how it works. It's difficult for you to see, but once you see it in person, in front of you, it'll make more sense. The top line up here reads, "We, the jury, find the defendant guilty of first-degree murder as charged in the indictment." If that's your verdict, you check that box. Then you make a further finding regarding the fire that was discussed in the instructions. On the second page is the lesser included charges of second-degree murder or manslaughter and the further findings. Then the last one you have is you find him not guilty. You only check one of the boxes on the far left. First-degree murder, second-degree murder, manslaughter, or not guilty, based off the law that I've read to you. If your verdict requires a further finding, then you go to the indented part of that request. And then the foreperson would sign and date it. Count 2 acts very similar, except it's a different victim, the unborn child of IS. For count 3, it's very simple. He's guilty of the crime charge or not guilty, and you sign and date it. There's no further finding on that one. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you'll be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. The foreperson will have the forms, fold them in half, give them to Mr. Gray or the bailiff, and then he'll give them to me. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, electronic communication, blogging, Twitter, email, text, etc. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, other electronic devices here in the courtroom. The rules do not allow you to bring your phones or these devices into the jury room. Mr. Gray and the bailiffs will collect them from you, and they'll hold custody of them until the end. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have voted, do not disclose the actual vote on the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. If you notice in the jury room, there's a monitor on the wall. It's not a TV screen. It's actually, well, it has no access to anything, internet, etc. It's just a big, essentially big computer monitor. The staff will set it up for you, turn it on for you. If you have any issues with that, let me know. It should have been checked out already. And they'll set you up to where you can put CDs in there, listen, view anything that you guys wish to do throughout the trial. That way you can all see it at one time versus a small computer screen. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. So in a couple minutes, the bailiffs will take you back to the jury room. I talked about scheduling. So you guys will begin your deliberations here in a moment. We will wait to hear from you on anything. I need to know by 6 if you guys want dinner. We will order you pizza if that's what you want. If at a certain time you guys want to break for the day and come back tomorrow, you just let us know when, and we will abide by your wishes as a collective group. Juror numbers 73, 75, 86, and 89. To break it to you, you 4 were our alternate jurors this week, which means that I cannot let you back in the jury room with the other 12. However, can't officially dismiss you yet What I'm going to do is go ahead and have the other, do you guys have any personal belongings in the room? You guys do? Okay. What I'm going to do is, if you guys don't mind, go and get those personal belongings and you'll come back out. And then I'll read you guys some additional instructions. Okay, so to the 4 alternate jurors, I have some additional instructions I need to read to you guys. This is specific to you guys, although it kind of applies to everybody. As you guys have already told you, I can't let the 4 of you into the jury room with the other 12 at this point. The law does not allow me to do so. However, I do not know if there's going to be another phase to this trial, as we discussed during jury selection. What I'm going to do at this time is excuse you from the courtroom and remind you that you are still remain under the order of this court not to have any discussions with anyone concerning this case, not to read or listen to any reports about this case. Because if the second phase is necessary, I am going to be asking you to return to participate in that second phase of the trial. The reason why we have alternates is because, especially in the cases that last, the length that we're here for, emergencies arise, acute issues arise, and if that's the case, the alternates have to step in. Fortunately, everyone's remained happy and everyone's remained healthy in here, so we haven't had the need for an alternate to step in. However, that need may arise next week if we go to a second phase. I don't know that right now, which is why ordinarily I would dismiss the alternates and say you're free to do whatever you want. I can't do that yet. You still have to remain under order of the court not to discuss the case like you have the past 2 weeks. However, I just can't let you deliberate with the other 12 right now. So I don't know, if we go to a second phase, I don't know when that's going to occur. We have your phone numbers, and we will call you and let you know next. Someone will call you either way. I'll let you guys know either way, because if you're not needed and you're dismissed, I want you guys to know that as well. But again, I remind you that you remain under order of the court not to discuss the case with anyone and not to read or listen to any reports about the case. No one is allowed to contact you concerning this case. At this time, I thank you very much. I'm very happy that the 12 have been able to remain here the past week and a half. And you're technically still a member of the jury and still under direction of the court. Your notes have been collected. We're going to keep them because if you need them later on, we're going to obviously give them back to you. So I officially thank you. I have your numbers. And as soon as we know something, I'll certainly give you guys a heads up and notify you as well as to what the next step is. So we'll talk to you guys soon. Okay, so to the 12 of you, you guys will now be taken back to the jury room here in a moment. The clerk will collect all the evidence and the jury instructions and the verdict forms and bring them to you. Mr. Gray will collect your devices that we talked about. And given the instructions I mentioned earlier, we'll wait to hear from you. You can officially bring your notes with you. Oh, I'm sorry. One thing. I failed to mention this. So we have a firearm and we have ammunition. I can't give them both to you at the same time. I'll give you the firearm. If you wish to switch, let the bailiffs know. jury's outside our presence. You guys may have a seat. I still have counsel for the state defense and Mr. Quiles present. Any exception or objection to the jury instructions as read to the jury? First from the state defense. There were a couple typos I want to fix on the jury instructions. Nothing major. I read it correctly to the jury. I just want the paperwork to reflect what I read. There was a couple, yes. Yes. So I'm going to fix that before we go back. Okay, I'm getting a clean copy. Otherwise, is there anything else we need to handle outside the jury's presence? First from the state defense. Okay, the jury will be provided the instructions, the verdict forms, and the evidence, and just we'll wait to hear from them. They've been clear instructions about how we're going to proceed tonight. So the ball's in their court. So we're in recess. excuse me, let's go back on the record, 19 CF 7518. We have counsel for the state defense and Mr. Quiles present. Anything we need to do before the, my understanding is we do have a verdict. Anything we need to handle before the jury comes out first from the state?
Yes, sir, Your Honor.
Defense?
Dan, did you want to address the second part, or you want to worry about it later? Okay. Nothing for the defense, Your Honor.
The only thing I will add to those in the gallery, obviously I don't know what the verdict is, whatever it may be, if you don't feel like you can contain your emotion, I ask that you step outside the courtroom now. If you know yourself and know you cannot contain yourself, please just step outside now and you'll be informed of the verdict. With that said, please get the jury. And Mr. Gray, just get the verdict form folded in half and give it to me.
Never happened before. Kids, you know, like that.
Those horror stories.
Your Honor, the jury returns to the court.
All right, the verdicts are legally sufficient. I'm going to give it to the clerk for publication. Mr. Quiles, please rise with your counsel.
In the Circuit Court of the 4th Judicial Circuit in and for Duval County, Florida, case number 16-2019, CF 7518AXXXMA, Division CRI, State of Florida versus Johnathan Quiles, verdict count 1. Plead the jury found the defendant guilty of first-degree murder as charged in the indictment. We find the defendant did actually possess and discharge a firearm during the commission of the offense. Verdict count 2. We, the jury, find the defendant guilty of first-degree murder as charged in the indictment. We find the defendant actually possessed and discharged a firearm during the commission of the offense. Verdict count 3. We, the jury, find the defendant guilty of engaging in an act that constitutes sexual battery upon or with a child 12 years of age or older, but younger than 18 years of age, by a person in a familial or custodial authority, as charged in the indictment. So say we all that in Jacksonville, Duval County, Florida, signed by the foreperson, dated September 21st, 2023.
All right, counsel, Mr. Quiles, you may have a seat. Does either side want the jury polled?
Yes, Your Honor.
Members of the jury, the clerk is simply going to ask you individually a question whether this was indeed your verdict. I want you to disregard your jury numbers from last week. We're going to start from my far right first row, juror number 1, work our way down, and then commence back on the top row. So 1, 2, 3, etc., and we'll finish up with juror number 12 on my far left. So she's going to ask you a question, and you just respond with your answer.
Juror number 1, were these your true and correct verdicts? Yes. Juror number 2, were these your true and correct verdicts?
Yes.
Juror number 3, were these your true and correct verdicts?
Yes.
Juror number 4, were these your true and correct verdicts? Yes. Juror number 5, were these your true and correct verdicts? Yes. Juror number 6, were these your true and correct verdicts? Yes. Juror number 7, were these your true and correct verdicts? Yes. Juror number 8, were these your true and correct verdicts? Yes. Juror number 9, were these your true and correct verdicts?
Yes.
Juror number 10, were these your true and correct verdicts? Yes. Juror number 11, were these your true and correct verdicts?
Yes.
And juror number 12, were these your true and correct verdicts? Yes. Thank you.
Members of the jury, this is typically when in the process I dismiss you from your service. However, we need to move forward with phase 2 of the proceeding. That will not occur tonight. It will not occur tomorrow. I'm going to give you the day off tomorrow. We're going to start back up on Monday for that process. That's what I told counsel as we were planning this out, and I want to abide by that. That phase, and the attorneys agree, is not nearly as lengthy as what this process is. A couple of days is what they anticipate. We may be able to conclude it on Monday. It depends how things shake out. Therefore, you're still under the order of the court to not discuss this case among yourselves or each other. Well, you discussed the case. You can't discuss it again moving forward. Please disregard the media. Please don't watch the news or the newspapers. I know it's a 3-day weekend. Please stay away from that. It's very important you do so. I'll have your 4 other friends come join you back on Monday, and we'll reconvene at that point. I haven't talked with the attorneys about this, but I'm tempted to begin later on Monday. Monday traffic's a bit more chaotic than the rest of the week. Why don't we start at 10 o'clock on Monday? Give you guys a late start. You guys can have a cup of coffee on me. Just tell them that, see what happens. But we'll start at 10 o'clock on Monday. We'll have a full day again. We'll go from there. I'm going to talk to the attorneys today and probably tomorrow and get an idea of what next week looks out for us. At this point, I'm going to dismiss you guys for the day. You can get your belongings and just meet. I trust you guys to get here on time Monday. Get here before 10 o'clock, same place as you have the past couple weeks. Just remember, do not discuss this case with family or friends. Please stay away from the media and the newspapers. If you see it, mute it, walk out of the other room. The same thing you guys have been doing the past 2 weeks. You guys have been wonderful, and I commend you guys. It's a solemn responsibility, and I'm grateful for you guys' service. And with that said, I'll see you guys Monday morning at 10 o'clock. The jury's outside our presence. You guys may have a seat. Anything we need to handle? Hey.
Your Honor, we read reports of documents that we talked about.
About Monday? Yeah, I told you guys that earlier in the weekend. I want to abide by that so you guys have time to prepare over the 3-day weekend. Anything from the defense perspective?
No, sir, Your Honor.
I do want to have a short status conference tomorrow to talk about the penalty phase, scheduling wise, instructions. The aggravators listed by the state, the mitigators listed by the defense. I want to get a clear idea as to the mitigators, statutory and non-statutory listed by the defense and pleadings, and have that box so we can, because they need to be listed in the instructions for the jury. I want to have a good idea of that. I know the defense has filed a couple pleadings with statutory and non-statutory ones. Some of the non-statutory ones you listed seem to be listing aggravators, but like in the inverse, how that aggravator is not met, and that may be what you're arguing as a non-statutory, but I just want to get a good idea of what we're talking about and what we have discussed so far.
I advise the court about 90% of it is just character, Judge.
Okay, well, I want that to be specifically delineated in a pleading. That's what I'm going to talk tomorrow about getting that one pleading properly filed with the clerk. So it lists out everything, and that's a combination of what you already filed into one pleading. That's fine. But I think it's important to have that one pleading done so we can handle that.
You want it before we come to court tomorrow? Or
you can have a draft done, and we can talk about it tomorrow if you would like.
Perfect. That's what I needed to know. What time are you talking about, Judge?
And I know you have Dr. Rohr, correct?
Sorry?
You have Dr. Rohr?
Yes.
Okay.
And I can tell you that it's going to be very short. The state and I, we're meeting with Dr. Rohr here at noon so that Mr. Skinner can go over whatever needs to be done, and he will have a full opportunity to be able to speak to her tomorrow at noon.
Did she do the IQ test you mentioned in the pleading?
Yes.
Okay. What time do you guys want to have a status tomorrow? I can't imagine it'd be lengthy, but if you have that noon meeting, what do you want?
Yes, sir. We're trying to meet her at noon.
Yep.
So we're
11's fine with me.
11 o'clock, great.
Okay, we'll have it in this courtroom as well, since that's why we're here. Certainly appreciate you guys. I know it's been a long couple of weeks. Appreciate both counsel on both sides for your professionalism and how you guys conducted the trial. It's not easy. I recognize that fact as well. So appreciate you guys. And I'll see you guys back at 11 o'clock tomorrow. We'll be in recess.